Welcome to the second day of the Football Law Annual Review 2019. I hope that many of you are joining us. We made sure that you can follow us again today in the 3 languages, so please join us via FIFA.com. Look for the news of the day. You will find that today we have the FLAR, and on the English page you have the link for the Spanish stream and for the French stream. Today we have a very intensive day. As I announced already yesterday, it's a day fully dedicated to transfer matters. We will start the meeting today with an update and with the figures about the Football Global Transfer Report 2019. And it's my pleasure to welcome Jacques Blondin, the FIFA head of TMS. Jacques, the floor is yours.
Thank you, Maya. Hello, everyone. It's nice to be here, and I'm very happy to open this second day of the Football Law Annual Review. It's going to be a challenging task, mine, because I have to talk about figures and numbers during a legal conference. As a lawyer, I know that lawyers generally prefer to work with words and definitions rather than with numbers and figures. But I believe that by analyzing altogether the figures that I'm going to show you, we will be able to better understand the market where we all work and operate, to understand its evolution and where it stands right now. Before starting, just some concept to keep in mind. The figures that I'm going to analyze today refer to data that are included in TMS. TMS is the transfer matching system, a mandatory tool that must be used in order to transfer players at international level. Therefore, today we're going to talk about professional players that are transferred at international level. Therefore, no reference whatsoever to national transfers. We will analyze 2 different aspects of the market. We will look at the men professional football and women professional football. What is important to know is that since October 2010, as I said before, TMS became mandatory. At the beginning, it was mandatory only for men. Subsequently, in January 2018, it became mandatory also for women, as long as they were professional players. And last but not least, in 1 week, 1st of July, it will become mandatory also for amateur players. Therefore, in 1 year, we will be able to show you figures and stats concerning international transfer of amateurs, both female and male. Some other point to keep in mind is that, and it's something that many people probably don't know, is that the registration periods are always open, all over the year. If you pick a random day of your choice, no matter which month, you can be sure that at least 1 registration period is open. Therefore, in TMS, there are constantly movements of players from a country to another one. Of course, this is in principle. As you may know, COVID-19 had a huge impact on football, including the registration periods. Therefore, many federations already contacted us in order to amend the registration periods due to the postponement or rescheduling of their seasons. And therefore, next year, we will be able to look back at what will happen in the upcoming months, and maybe this principle of always having a registration period open at any time will not be respected. But this is something that we will discover in the upcoming months. Let's start with the first section, which refers to men professional football. These are some numbers about the evolution of the total number of international transfers. As you can see, since 2011, the first full year where TMS was operating as mandatory tool, until 2019, there was a great increase of transfer of more than 6,000 transfers if we compare 2011 with 2019. What is also interesting, in my opinion, to see that the biggest difference that we saw from 1 year to another occurred actually between 2018 to 2019. There was a considerable increase of transfer, more than 1,500 transfer more. And this is a pattern that shows how more and more players are transferred internationally. So it's a market that is constantly growing. I had a look, and this is just a small anecdote, of the first ITC that was ever issued in TMS. This was still in 2010 at the very end of the year. It was not a transfer that ended up on the newspapers. It was just a transfer of a Dutch player, a free agent, that moved from the Netherlands to Indonesia out of contract. Although I guess that not many journalists wrote or spoke about that, it was definitely a milestone for TMS. So with respect to the moments where the transfers occurred, we can see these stats that confirm what I've said before. As you can see, there are always some transfer taking place during the year. There was no month without transfers. And it's quite remarkable that there are two periods where we have a peak of transfers. Not a surprise, July, August is always a very busy period of the year with the big leagues and federations having their registration period one open. So the registration period that is right before the beginning of the season. And therefore we always witness many transfers both in July and August. But what is very interesting to me to underline is that also January and February are very, very busy. If we think of what are the elements that cause this increase of transfers in January and February, I think we can find two different elements. The first one is that in those countries where the season runs from January to December, football had a huge evolution, grew a lot, and we've seen more and more transfers going to those countries. And another factor that has to be kept in mind is that also in the countries where the so-called European model is followed, therefore a season that runs approximately between June between July and June, many transfers, also important transfers, took place in January. Therefore, for those federations, those leagues, the January registration period is not anymore just a period of the year where clubs tend to make very few transfers in order to fix maybe some issues that they have in their squad or to replace some injured players. Is actually a very important and central registration period to close also very important deal, both in terms of amount of money spent and in terms of number of transfers. And if we want to have a look at the type of transfer that we witnessed in TMS in 2019, we can see this chart, and we find 6 different transfer types. Those are the type of instructions that can be entered into TMS. Therefore, we have the permanent transfer, is the classic transfer with an agreement between 2 clubs for the permanent transfer of the player to club A to club B. Then we have the transfer that is out of contract, therefore a free agent that is not under contract with his previous club and is moving from one federation to another, signing an employment agreement with a new club. Then we have transfers related to loan. We have the typical transfer instruction for the loan of a player to another club, the return from loan, the loan extension, and the possibility to make the loan from a loan transfer, so a temporary transfer to a permanent one. What is remarkable is that even though football fans, when they think about the transfer market or big transfers taking place, they always think about those big transfers with a lot of money spent in transfer fees from one club to another. But actually, if we look at the statistics at international level, the majority, almost 65% of transfers refer to players that are out of contract. Therefore, behind the scene, what is generally not perceived by the spectators is that there is a big number of players that move out of contract, and this is a big portion of the football market. It's also remarkable, in my opinion, to notice that last year we had more loans than permanent transfers. So actually the permanent transfer, that in my opinion is the type of transfer that football fans always think about, only got the bronze medal last year. And now we come into the part that I like the most, is about spending. Again, I want to remind you that we only talk about international transfers, no reference whatsoever to national ones. And we can see once again the pattern that shows a constant growth in the spendings at the international level. But the difference here between the amount of transfers is that in 2012, there was a small decrease, but then it grew constantly, continuously. And we reached the top last year with $7.35 US. I'm talking about billion here, spent for international transfers of players. And as I was saying before, these figures are very important for all of us in order to understand the type of market where we are working. And we speak about these very big amounts only referring to international transfers. If you add to that those transfers that take place between clubs affiliated to the same federation, the final outcome would be way higher. But it's good and it's important for all of you to understand also the type of transfer fees that are declared in TMS and how much TMS became important in order to guarantee transparency and compliance with the rules. Such an important market needs to be regulated. And now we see the proportion that exists between the number of transfers and the money spent. And if you remember 2 slides before, the percentage of transfers of players that are out of contract, well, this slide will not surprise you. We see how there is a constant pattern here as well of big disproportion between transfers with fee and transfer without fee. In 2019, slightly more than 85% of transfers were without fee. Therefore, we could see that a market that is increasing a lot in terms of money spent and also number of transfers, but those money, that money is concentrated in a very small percentage of transfers. And this was something that more or less, with some slight variation, was repeated year after year. Therefore, a takeaway here to keep in mind is that a market that is constantly increasing, but that has the spending focused on a very small percentage of operations. And this, again, slide that confirms what I was explaining before, but it shows really the different digits, a very high number of transfers without fee. But then when we look at the transfer with fee, we see that the most common one are transfers that take place for a transfer fee between 100,000 and 1 million. Transfer above 10 millions were only 176 last year. Therefore, once again, the big transfer that we generally read about in the newspapers are just a very small portion of the global market. And again, talking about fees, I would like to show you now the percentage of the different fees that are declared in TMS. We have 3 different possibilities in TMS. Whenever a club has to enter a transfer instruction, then has to declare if any money is spent and if there is any fee, what type of fee. There are 3 different categories. We have the fixed transfer fee, which it's an unconditional fee that is agreed between the two clubs can be paid in one shot or in different installments. And clubs have to declare in TMS all these aspects, the terms and the values and the installments, if any, of this fee. Then we have the second option that is the conditional transfer fee. The name is already quite clear, are those fees that are subject to the fulfillment of a condition, of a requirement that is previously agreed by the clubs. A very common one is are those conditions that are related to the performance of a player. If, for instance, a player scores more than 10 goals or plays more than 25 games, one club is obliged to pay to the other one a certain amount of money. And then there is the third category, it's the so-called buyout, that correspond to a very small percentage of the market. And now, another type of fee that is not included in the previous chart, because here we're not talking about an amount of money, but we talk about a percentage, is the sell-on fee. Sell-on fee that has been very discussed by many lawyers, and it's important to see how it is becoming more and more used in the system. Last year was the first year that we really provided an in-depth analysis of the sell-on fee declared in TMS, and the outcome is very interesting because we can see that in almost 50% of those transfers that are made against the payment of a certain amount of money, there is a transfer fee. It's less common in those transfers without the payment of a fee, and it corresponds to almost 10% of the global transfer market. It is very interesting to me to see that these figures show how this clause is becoming more and more used in agreements between clubs. And then when we look at the type of clauses that we generally find, the most recurrent one is the sell-on fee for a percentage between 10 and 20% of the future transfer of the player. It's interesting to see that in 27 cases we found sell-on fees for a percentage that was above 50%. It's interesting to see how this clause is used differently by clubs. And now transfer streams. I prepared two different tables. On the left side, we have the streams between country with respect to number of transfers. And on the other side, on the right side, we have the streams taking into account the money spent. Let's have a look at the first one, so at the numbers of transfers, and you can see that it's very diverse. We have diverse names, diverse statistics. It's interesting to see that the first, and not even surprising, that one of the most recurrent streams is from Brazil to Portugal. It's well known that many Brazilian players or players from Brazil reached Europe by going first to Portugal. And then we noticed that there are many transfers as well between England, Wales, England, Scotland, and the other way around. These can be easily justified by the fact that in the United Kingdom there is a specific situation where one country has 4 different member associations. This, of course, facilitates the movement of players in this region. And then there are other streams that, at least to me, the first time I saw them, I was quite surprised. For instance, transfers from Russia to Armenia, or transfers from Argentina to Chile. So very different names. But then if we look at the other side, and when we look at the money that were spent from which club, from which country to which country, we can see that there are, with the exception of Portugal, that is in the 4th line, for the transfer from Portugal to Spain, there are 5 names that are only represented. And those are the names of the so-called Big Five, the 5 federations in Europe, England, Germany, Spain, France, and Italy, that always played a very important role into the market at the international level. Of course, here we're talking about spending made by clubs affiliated to those federations. Nevertheless, it's interesting to see that the streams from Portugal to Spain economically were still very important. And there's no need to mention the name of the player, but there was an important transfer from Benfica to Atletico de Madrid that certainly had a huge impact in order for this stream to be placed at the 4th position last year. So I mentioned the Big Five, and I think it's now the time to have a look at what happened last year during the European summer, so the registration period 1 for the Big Five Federation. This is, first of all, an overview of the spendings that take place that are made by clubs affiliated to the Big Five. The difference between those 5 federations and the rest of the world is impressive, in my opinion, especially England, always at the lead since 2015. Spain has been growing a lot, and last summer, the spending was almost identical to England, whereas Italy, Germany, and France were always more or less at the same level. 2017, France reached the same level of Spain. Again, no need to mention the player, but also in that case, there was a transfer from Barcelona to Paris Saint-Germain that certainly helped France to make this important leap. And the rest of the world is at the very bottom. Why? Because the difference of spending is very, very important. And in this respect, again, referring to the European summer of last year, 2019, the statistics tell us that 76% of all spending came from 5 associations, so those 5 associations, the Big Five. 47% of all spending came from only 50 transfers, and 48 of the 50 most expensive transfers were to 5 associations. Again, those 5 associations. And this goes a bit in line with what I was saying before, that globally speaking, the market is growing in terms of number of transfers, but the money that is spent is focused, is concentrated in few countries and for a very little amount of transfers. If you're wondering who would be the 6th one of a potential Big Six, it would be Russia. Nevertheless, the gap between France, that is the 5th one in the Big Five, and Russia is still very big. And intermediaries are also declared in TMS, so we have information about them as well. Here is an overview of how many times intermediaries are declared in TMS. We see that based on the information included by the clubs, there was a constant pattern since 2014. There was approximately around 7% for engaging clubs, so in 7% of the transfers was an intermediary representing an engaging club, between 15 and 14% representing a players, and around 6% representing the releasing clubs. And with respect to commissions, again, we base ourselves on what was declared in TMS by the clubs. The balance is way in favor to engaging clubs. Engaging clubs is always spent more in intermediaries commissions than releasing clubs, even though we could see that last year 35% of commissions were spent by releasing clubs. As you can see, there is no information about commissions paid by players, because players do not have access to TMS, and therefore clubs are not requested to declare the commission that a player has to pay to an intermediary, if any. Therefore, we do not have information about that right now. Let's now have a look at women professional football, the other portion of the market that is growing. We have information, as I said before, about this part of the market only since 2018. The figures, and it's not a surprise, are very different. Numbers are way smaller, but nevertheless, what is interesting to see is that both in terms of number of transfers and in terms of spending, there was a considerable increase for both items. And keep in mind that, as I said before, right now we only have information about professional players. There are many women that have been transferred, but to a country where they were not registered as a professional. Therefore, at least in terms of numbers, so the figure on the left side, those transfers are not reflected. Nevertheless, as I said before, as of 1st of July, we will also have information about that. And next year, we will be more than happy to share this information with you to see how also women football is growing. This is a bit an overview of where transfers took place. Again, important to see that transfers took place all over the year. The type of transfers, here it's even more clear that there are more transfers involving players which are out of contract, more than 86%. And in terms of fees, similarly to the men football market, the fixed transfer fee is the most common one. Then we have the conditional, and finally the buyout. And with respect to sell-on fees, the number of sell-on fees that we could detect correspond only to 1.3% of the total market, so way less than for men. And the last part of the transfer market that encompasses both men and women is about minors. I'm not now going to enter into the legal details of minors, but for you to have an overview of what happened last year and the evolution that we could see during the years, is that there was a continuous increase in the amount of minor applications. And last year, more 92.5% of applications were accepted. It's a good signal. It probably means that member associations learned the documents that they have to provide, and also that probably we could see less and less minor applications for those players that cannot benefit for one of the exceptions provided under Article 19. And talking about exceptions, this is an overview of the type of exceptions that were generally used in order to transfer a minor player. The most common one is the first one, the parents moving to another country for reasons not related to football. Then there was the application of the 5-year rule, provided for under Article 19, paragraph 3. And then the 50-kilometer rule, so those players that live next to the border and go playing football in a city on the other side of the border. The most common age was 16 years old. And the status of the players that were subject to a minor application is the following. We had 95% of transfers, or actually minor application, involving players that were to be registered as amateurs at the association, and only 5% of professionals. And what's next? As I mentioned, in 1 week time, TMS will become mandatory also for international transfer of all amateur players. Therefore, there was an amendment of the rules, in particular Article 1.5 of Annex 3 of the regulations, which establishes that TMS is mandatory for all international transfers of professional and amateur players, both male and female. In terms of the information that will be entered into the system, we will see less options for clubs, because the transfer of an amateur has, by definition, the following characteristic, or should have, by definition, the following characteristics. It's an engage of a player, because it's transferred from one club to another permanently. There is no loan of amateurs, since the amateur player is not bound by a contract with the other club, without a transfer agreement for the same reason, and free of payment. Therefore, a club should not pay another club a transfer fee for the transfer of an amateur player. So we're waiting to see how the market will react. What are the figures that we will see in TMS with respect to amateur players, and we will see next year other stats about that to learn more about the market where we all work and operate. Thank you very much.
Thank you very much, Jacques. This has been a very interesting presentation. I have some questions for you. We have some viewers that take advantage of having the head of TMS in this conference, and they would like to ask you some general questions about TMS. I see here a question from a club in Saudi Arabia that enters in TMS as engaging club many deals, and they receive player's passport from the former federation of the player. Mm-hmm. And the issue is that many of these players' passport refers to the clubs that train the player within the former federation of the player, but there is no reference of the clubs of which trained the player before that former federation of the player. The club representatives would like to know if there is any way to create a new tab in TMS, which could be called the player's career, similar to the player's passport, so that the engaging club can navigate through the history of the player electronically and accurately on the basis of this transfer, then conclude all the transfers in TMS. So basically, in short, the question is if there could be something new created in TMS called as a player's history career.
Thank you, Maya. Thank you for asking the question. Actually, the system will change together with the creation of the clearinghouse. There will be the electronic player passport, which will reflect the player's career, the player's evolution, in order to avoid the situation where a new club doesn't know who is entitled to training compensation or solidarity. And for that, other amendments were made to the regulations, ordering all member associations to use both electronic registration system and a domestic transfer matching system, so that all this information can be then included in an electronic player passport in order to provide complete and accurate information about players. Therefore, there will be no such a tab as the one suggested, but something very similar, which will be the creation of the electronic player passport, which is based on the federations using this electronic system. It is very important to keep in mind that, because also now based on the regulations, if a player is not registered electronically, the registration is invalid, and therefore the player cannot play organized football for the relevant club. And I think this is the key that will make also the player passport change completely.
Thank you very much, Jacques. I have another question from a lawyer in New Zealand, and he would like to know if TMS compliance has started any investigation of any bridge transfer yet. That's the question.
Not yet. We received many questions, so we mainly dealt with general requests, which refer to hypothetical scenarios. We were supposed to start, but due to COVID-19, all registration periods have been postponed. Therefore, there was officially not case yet involving transfer based on new Article 5bis.
Then I have another question, which is also about more TMS compliance. It's from a lawyer in India, and the question is in connection with payments to intermediaries, and if there is any proposal to implement in the regulations for intermediaries in TMS any compliance situation for the payment. What are the next steps that you could elaborate a little bit more on this question?
Well, there will be now a very interesting presentation about the new rules concerning intermediaries. What I can anticipate is that we are working very closely with our colleagues from the intermediaries department because the intention is exactly to also run compliance with respect to any fees for intermediaries that is declared into the system. Therefore, I confirm that the idea is to implement our stricter and more focused approach to that in order to ensure that there is compliance whenever an intermediary is involved in a transaction.
Thank you very much, Jacques. I have another question. It's an agent, an intermediary, and he would like to know how FIFA is going to ensure that the correct training club is actually being in the player's passport. So how is FIFA running any compliance that it's the correct club that appears in the player's passport?
So we're currently working on the new regulations concerning the clearinghouse, and there will be a procedure that will allow those clubs that are missing in the electronic player passport to be included. And together with this process, there will be also the possibility to have the sort of compliance or investigations that are carried out for all those cases where club was not included in the electronic player passport due to some misconduct of whatever party, can be the federation or other party. Therefore, the idea is, in order to make the clearinghouse system efficient and robust, is to ensure that rules are respected, and therefore we will surely run compliance also with respect to those training clubs that are included or not in the electronic player passport.
Thank you very much, Jacques. I have another question. Here is now a question from a student in Chicago, and he would like to know what steps does a training club need to take in order to not miss that they have trained a player at a young age?
Well, of course, member associations play an important role there, but because they are the ultimate responsible to indeed register the player. Nevertheless, I think that clubs must still ensure that all information about players that are registered with them or for them actually, and they are attending their facility, they are part of their teams, are provided to the federations. That we have to avoid that there is any type of miscommunication or that clubs simply do not inform their member association about some players there that is them, because in the future this could be detrimental to them. The federation never received any information, and the club can miss the opportunity to get training rewards. Therefore, although member association are the ultimate responsible, clubs also play a very important role and need to cooperate and to provide all information to the federation and request the correct registration of the player.
Thank you, Jacques. Looks like South America is also awake. I have a question from there. They want to know if an amateur player is not playing for the last 6 months with his former club, if then in TMS that player can be registered with a new club abroad in another association?
Well, there are rules about the, the lots of time that have to run before a player is to be considered not registered anymore with federation. Once this time has elapsed, then indeed the player is not registered with a federation anymore, and therefore there will be no real international transfer because there will be no issuance of the ITC. But what is important is that whenever an ITC is to be issued in order for a player to be registered to another federation, that then that transaction, that transfer must be reflected into TMS.
Thank you very much, Jack. And I still have one more, and then I will not ask you any more questions for today. Here we have a question. It's more a little bit academic, or it's if FIFA foresees in the near future to implement some measures in TMS, for example, some specific cooperation with law enforcement authorities.
Well, there are many ideas on the table for us to give to our investigations more tools in order to find those big infringements, because our idea is really to avoid that some serious misconducts take place. Even though we do not officially cooperate with law enforcement, there have been some cases where through the member associations we managed to obtain documents from law enforcement authorities, which were crucial for our investigation. But of course, we're open to many possibilities. The idea is to make our investigatory tools always stronger, and therefore this is something that we're already keeping in mind.
Thank you very much, Jacques. I don't have any further questions for you for now. So thank you very much for your presentation. Before I move to my next speakers today, I will just like to clarify again that you can continue to send us all your questions to the email address that you have been sending them, which is the annual review FIFA.org, that you can send your questions in the 3 languages that we are having the event today, which are in French, Spanish, and in English. And for all of those of you who missed us yesterday, and those of you who maybe are not yet ready today to follow us, please, I can clarify that we will share with all of you today's presentations, the videos, yesterday's presentation, and the videos in the 3 languages. All of this will be available on legalfifa.com within the next few days. So in case you missed us, you can watch us again and you will be able to have a look at all our presentations. But now I would like to come back to the program. It's my pleasure to announce my next speaker, my friend, my colleague, Ornella Desiree. She is the FIFA head of professional football, and she will give you the first part of the reform of the transfer system, the update. Ornella, the floor is yours.
Thank you very much, Maya. Hello, everyone, dear friends of the football community. Good morning, good afternoon, evening, whenever you are in the world. I hope that you and all your families are doing okay during these difficult times. It's an absolute pleasure to address you today, unfortunately not from beautiful Buenos Aires, but from the amazing home of football here at FIFA in Zurich. As some of you know, I joined FIFA quite recently, less than 1 year ago, so this is my first football annual law review as member of the FIFA family. And I can tell you it's really an honor for me to be here and being part of this dream team led by a real top player, our Chief Legal Officer, Emilio Garcia. who is doing really a great job in helping FIFA democratizing football by organizing also this kind of knowledge sharing events. So today we are going to talk about the reform of the international transfer system. I'm here with Luis Villas-Boas, who will talk about the reform of intermediaries, while I will talk about a general overview of the work that has been that has been done by the task force and the football stakeholder committee during the last year, but also that is going to do in the upcoming months. So first of all, it's important to understand why did FIFA decide to reform the transfer system. You might know that since 2016, when the FIFA president Gianni Infantino was elected, he had clear the fact that the current FIFA regulation, the status and transfer of players, were out of date and were actually facilitating certain abusive practices. So the reason to reform the transfer system was to ensure a proper functioning of the football market and especially promote a more sustainable football ecosystem. So I always say that when we plan for the future, we have to understand the past. It's super important. So if we look back at 2001, actually, at that time, the new FIFA regulations were released, and the basic principles were encouraging training of young players, protecting contractual stability, protecting minors, and also favoring solidarity. These were the basic principles that were implemented at that time in the FIFA regulations following the negotiation between FIFA, the European Commission, and the other stakeholders following the Bosman case. But since 2001, of course, many things have changed, especially in football. Over the last 2 decades, football has changed a lot. We know, of course, that football is no longer a sport, just a sport, but has converted into a multi-billion-dollar industry. We know that, of course, the reason for this massive commercial growth is due to the TV rights, to the increase of TV rights values, and of course, the fact that certain markets, certain leagues have been able to monetize the popularity of their competition in a huge way. So this means also that certain leagues and also certain clubs from specific markets were able also to be successful both from a financial and sporting perspective, and this has determined a certain competitive imbalance in the international football ecosystem. So keeping in mind all this evolution in the football ecosystem, FIFA has decided back in 2017, when the reform process kicked off, to analyze facts and figures and see what can be improved. So just for you to understand the evolution of the football transfer market and the evolution, of course, of the TV rights, which have had an impressive impact on the transfer system, we can see this chart where we can actually see the amount of money that the Premier League was able to monetize in the 5-year cycle 92-97, where the Premier League managed to sell the rights for just 240 million. And if we look at the last cycle, the 3-year cycle 2016-2019, actually just in 3 years, the overall value of the TV rights was 8 billion. So from these slides, you can of course understand how football has changed. But I think there is also another takeaway that we can see in these slides. The fact that, of course, we are aware that not all the leagues, not all the markets are able to monetize TV rights in such a way, in such a massive way. So this means that there is quite a huge difference between certain leagues and other leagues in Europe, but especially out of Europe. And therefore, there is a kind of balance in the international football ecosystem. As my colleague Jack Blondin, head of TMS, as already mentioned before, the international transfer market has experienced also an increase in the number of international transfers of players, but also an increase in the value of the transfer fees paid during the years and year by year. Actually, last year was a total of 7.35 billion. There is another interesting slide, another interesting fact and figures regarding intermediaries fees and training compensation fees. If you look at this blue column actually represents the amount of money that has been paid to intermediaries. And the column in light blue and in gray represent the amounts paid to training clubs for both solidarity mechanism and training compensation. So you can see the huge difference between these these figures. And of course, we can say that definitely solidarity, which was, and training rewards that were two of the basic principles of the FIFA regulation back in 2001, are not being achieved. If we look at this chart, we can see the winners in the last 10 years in the top 5 European leagues, and we can see that especially in certain leagues and especially in certain markets, there have been certain clubs that have been able to be successful both from a sporting and also from a financial perspective. So keeping all these facts and figures in mind, FIFA realized that actually the market was driven by speculation rather than solidarity. The money was flowing away from the football family. There was a greater contractual instability, an increase in massive inflation of transfer fees and players' wages, and an increase in competitive imbalance. So the original objectives of the FIFA regulations are not being achieved. And this is the reason why the FIFA leadership decided to kick off the reform of the international transfer system. With so many interests at stake, interest of clubs, leagues, member association, players, confederation, and so on, FIFA set the Football Stakeholder Committee, a committee which is a consultative body which provides with all the amendments, all the proposal for the amendments of the FIFA regulations, and is also in charge of other topics, club football, the structure of the game, and so on. This committee, which is a consultative body of the FIFA Council, is composed of representatives from all the stakeholders. So it means from FIFPro, the Players Union Association, from ECA, the European Club Association, but also from non-ECA clubs, so clubs from all around the world, the World League Forum, the association comprising all the leagues at international level, and then of course our member association and confederations. This Football Stakeholder Committee is led by the chairman Victor Tajani, who is the president of CONCACAF and vice president of FIFA. And at the beginning, when the transfer reform was kicked off in 2016, a task force transfer system was also established in order to deal with the technicalities of these matters, of these changes. So as I said, in February 2017, the reform was kicked off. The first reform package was approved in October 2018. With the approval of the clearinghouse and the electronic registration system. Corrado Plano, our colleague Corrado Plano, head of clearinghouse, has given a presentation yesterday about the clearinghouse. So Luis and myself will focus on the second reform package, which is on loans, agents, and training rewards, and which was approved in October 2019, so just some months ago by the Football Stakeholder Committee first and then by the FIFA Council. When it comes to the third reform package, unfortunately due to the COVID-19 crisis, we haven't been able to work on those pending items. We have been busy with the COVID response, the COVID regulatory response. So we have worked on these FIFA guidelines and FIFA FAQ to give stakeholders with some guidelines, but we still have on the agenda some pending items, like, for example, minors, fiscal regulation, transfer windows, and squad size limits, which we intend to address in the coming meetings of the Football Stakeholder Committee and the task force. And the date for the final approval, of course, is still to be decided. So when it comes to the training compensation, so basically the current system, we made an analysis, of course, of the current system, of the training reward current system. We realized that the system itself was not functioning in a very efficient way in returning money to training clubs. And also that the calculation of training amounts or training compensation was overly complicated. So we realized also that many clubs were not even able to monitor the international transfer of those players that have been trained, that they have been educating. So the objectives of this reform is to have a new system which will record in a better way training clubs, in a way that top clubs pay more and smaller clubs pay less, but also a simplified system, a system where the calculation is automatized and also the payment is automatized through the clearinghouse. So Conrado Plano has already given some information about the clearinghouse and its functioning. But here, when it comes just to the training compensation, we can say that all the payments as from January 2021, so just in 6 months from now, will be automated via the clearinghouse. 1% additional levy will be applied on every transfer fee to finance a FIFA training compensation fund. How does it work? Basically, this training compensation fund will pay part of the training compensation, and the acquiring club, the buying club, will pay the remaining part. So basically, the fund will pay more for smaller clubs, clubs from lower categories, and less for big clubs. So the big clubs will pay a higher percentage than there is also something new concerning the categorization, because the categorization of clubs will be done on an individual basis rather than on a division league basis, as it is at the moment. And also the criteria in order to categorize the clubs will be based only on the average training cost, but also taking into account the club turnover and also other objective criteria. So we are now in the process of making this new categorization of clubs and also making a calculation of the new training amounts. Indeed, these training amounts will be revised in order to bring them up to date, because when, of course, this was made was back in 2001. So there are also some news regarding, for example, when a player moves across categories. Let's imagine from category 1 to category 3. In this case, when players move across categories, the EU rule will apply worldwide. This means that the training amount will be the average between the amount of category 1 and the amount of category 3. So this is, for now, this applies just in Europe, but will apply worldwide in the future as of 2022. So the training compensation due for the season between the age of 12 and 15 based on category 4, so the amount will be, of course, lower. The transfers between the age of 21 and 23, the amount, the training amount will be reduced by 50%. And then, of course, as it is now, the previous clubs must offer the player a contract with equivalent to be entitled to training compensation. There will be a 1 year transition period. This means that as of January 2021, the new system won't enter into force. There will be just an automated, the payment will be made through the clearinghouse, but with the same categorization, with the same training amount. So the regulation will remain in place 1 year more before the introduction of these new provisions. So when it comes to loans, so the current system, as you know, there is a kind of lack of a clear purpose. Basically, the reason for allowing loans is the youth development, but the loans have been used for several reasons. So we realized that there was the need to implement, to make it clear that there is a sporting purpose behind the loan system, but also other principles are important, like the integrity of competition. So based on these principles and also the principle of promoting competitive balance, we have been working on some proposals, some basic principles that have been already approved by the Football Stakeholder Committee and by the FIFA Council. The new wording of Article 10 of the FIFA Regulation on the status and transfer of players regarding loans has also been approved by the Player Status Committee. The new regulation were supposed to enter into force as of July 2020, but due to the COVID-19 crisis, it has been decided to postpone the introduction of the new regulation to a later date. So when it comes to the main change in the loan regulation, we have the limitation on the number of loans per club. So as of the first season, which is no longer the season 2020-2021, but is to be decided, for the first season there will be a limitation of 8 loans in and 8 loans out per club, and then a limitation of 3 loans in and 3 loans out between two clubs, between the same clubs. For the second season, this limitation will be 7 and will remain 3 for loans in and out between the same clubs. And for the third year, the limitation will be 6 loans in and 6 loans out, and 3 loans in and out for loans between the same 2 clubs. This limitation won't apply to players who are between 15 and 21 years old and are registered with their current club for a period of 3 seasons or 36 months. Also, sub-loan will be prohibited. This has been already said yesterday. I hope there is overlap on what I'm saying, Maya? Okay. So, as I mentioned before, we have still some pending items on the agenda of the Football Stakeholder Committee. We have fiscal regulation, which is a sort of financial regulation. Then we have minors, transfer windows, and squad size limit. So when it comes to fiscal regulation, this is actually the only topic that has been addressed more in depth during the last 2 meetings of the task force. So basically, what do we mean by fiscal regulation? We mean all those measures addressing the financial flows in the employment and transfer market. There are some general objectives that we have identified, for example, protecting contractual stability, of course, protecting players' welfare, promoting a competitive balance at global level, financial sustainability of football club, transparency in the market, and of course, avoid speculation and dubious transaction, and the concentration of talent. Based on a proposal of FIFRO, we have also analyzed how the system could work, for example, with the establishment of a mandatory buyout clause, where the amount for such a buyout clause is determined based on objective criteria. We are also analyzing several other measures, like, for example, those measures that are in place across sports league all over the world, for example, salary caps, luxury tax, competitive balance tax, levy on transfer fees, economic and financial control system, and so on. But we are still discussing these measures. As you have seen recently, FIFA published the vision for the future, the vision to make football truly global, to create an ecosystem where a larger number of clubs and players are able to compete at the very highest level. And with all these changes, those regulatory changes that have been already approved by the FIFA Football Stakeholder Committee, but also those that will be approved hopefully in the near future, there is a clear objective to create a more competitive system, a more healthy competitive football ecosystem. So in line with these principles, it's my pleasure also to announce some projects of the professional football department that have been actually designed based on this concept, based on the FIFA vision, the FIFA dreams to make football truly global, to get closer to stakeholders, to democratize football, and to create a better football ecosystem. So by the end of the month, by the end of June, we will launch the FIFA Professional Football Journal, which is a platform to have debates among stakeholders, to share ideas, but also to bring the stakeholders closer together. Then, as of the next season, so in July 2020, we will launch the FIFA Professional Football Landscape, which is the first ever digital and dynamic database of professional football, analyzing the structure of the game both at international and national level. Also, as announced yesterday by our Chief Legal Officer, Emilio Garcia, the diploma in club management, which is a way to provide tools to executives from clubs from all around the world to be able to compete at the very highest level, not only on the pitch, but especially on the pitch. And then the Professional Football Hub, which is a digital learning platform, which will contain club business case and other insightful information for the benefit of the football community. So that's all. Thank you very much for listening. Thank you very much for your attention. I pass the floor now to my colleague, Luis Villas-Boas, the head of intermediaries. Thank you very much, Maya. I don't know if there is any question.
Very much, Ornella. So before we give the floor to Luis, we will give the floor to our viewers. And they have sent us some questions. So I will start with a few questions. We still have time for this. So we have a question from a lawyer in Ecuador. And he would like to know if, with all the upcoming amendments, if you could elaborate if there is any ideas of changing also the training compensation for women. So if in the stakeholders committee, if there is any view of this changes in the reforms.
It's a very good question. There are some discussions, not within the professional football department, not within the football stakeholder committee at the moment, but this has been already addressed by our colleagues from the women's football division. I know that there are these discussions, but we are really at a very early stage.
Thank you very much, Ornella. We have another question that is coming from a student in Germany, and it has to do with the COVID-19 guidelines. And the question, he would like to know if all the stakeholders at all, how the stakeholders, I'm translating here from my German, how the stakeholders were involved in the elaboration of the COVID-19 guidelines.
Yeah, I can say that the stakeholders have been involved and have been consulted during the whole process. We have actually negotiated with them all the matters, the new amendments to the FIFA regulation on the status and transfer of players. So they've been included since the very beginning. We have been discussing with them in several meetings, exhausting meetings sometimes, very long meetings, just to find a balance between the different interests of especially clubs and players, but also, of course, leagues, member association, and confederation.
Thank you very much, Ornella. We have another question from a lawyer in Vanuatu, and it's in connection with the loan regulations. They would like to know when we can expect that the loan regulations will come into force, and what could be the maximum length of a loan under the new regulations.
Okay, so I'm not in a position for now to tell when ideally the new regulation on loans will enter into force, because we don't know. Maybe ideally by 2021, but this has to be decided by the competent bodies. And regarding the length of loans, the maximum length of the loan will be 1 year. So the minimum will be between the two registration periods, and the maximum will be 1 year.
Thank you very much, Ornella. And we still have time for one last question. It is a question coming from the Netherlands, and it's actually, again, a student. He would like to know if the fans somehow could be taken into consideration as stakeholders, or if the fans could actually give their input when it comes to making new ideas for reforms within FIFA.
Officially, at the moment, the football stakeholder committee is not, is composed by all the stakeholders, but not by fans. But with this professional football journal, give a platform also to fans. So there will be an email address where you can send your questions, your input, your ideas, and I can assure you that these will be taken into account when we have the upcoming meetings of the task force.
Thank you very much, Ornella. I don't see any more questions for you, which means that we can now give the floor to your colleague. Thank you very much, Ornella. Thank you. And I am very happy to now announce Luis Villas-Boas, the FIFA head of intermediaries, and he will give you now his presentation and about the new reforms. Luis, the floor is yours.
Thank you very much, Maya, and thank you for everyone that is watching the FLAR. I'm super happy to be here and to present. I think it's one of the hottest topics in this in the FLAR from these 2 days. And I hope I can clarify all the questions and doubts we have in relations to this, to the agent framework that we wish to implement. So, as I mentioned, I will give an update on agents, which basically is part of the second transfer reform package, as Ella just presented. And my main objectives with this presentation is to answer to 4 questions mainly. The first one is why FIFA decided, along with these stakeholders, to start changing the current landscape of agents. The second one is what FIFA has done so far to change the current landscape. The third one is what are the principles of this new agent framework? And last but not least, we have the 4th questions that I hope I can answer is, what is the tentative timeline to implement this new agent framework? So let's start with the first question that we have in this slide. So why FIFA needs to change the current landscape on agents? As you can see from the slide, there are several issues that will emerge not only from since the deregulations of football agents in 2015, but also some issues that basically remain even before the deregulations in 2015. All these issues were sourced from internal reports made by FIFA, but also external reports that are publicized around the internet that it's easily to find. I'll give you some explanation to some of those issues. I believe the first one that we have in the slide is, and that again was sourced from these external reports, was the several activities conducted by agents that could be considered abusive and excessive. Meaning, there are several instances where we can find agents involved in creating and established non-transparent in financial streams, being involved also in criminal activity as money laundering, tax evasion, bribery, and so on. Then we have our data, as already was explained by both of my colleagues, Jacques and Nella, where the data is quite clear. It shows that the market is driven by speculation and not solidarity. Commissions paid to agents foster this speculative activity and damage the contractual stability, which is basically one of the fundamental pillars of the transfer system established by FIFA. Then we have evidence that it's quite clear from the right hand of the slide. We can see how the increase of commissions being paid to agents has basically skyrocketed, where last year, as with the FIFA TMS reports, we have 653 million commissions being paid, which is basically more than double in 5 years since the regulation. So while the money spent on football agents increase annually, the money reinvested through the transfer system, using the system with solidarity mechanism and training competition, has basically stalled. As I mentioned, we have spending on agent commissions last year on 653 million, while payments to training clubs are in a region of 75 million. We believe that the prospect of receiving a high commission may compromise the fiduciary duties of a football agent to act in the best interest of the client. In relation to this last point, we have another data, examples of multiple representation. There are examples of agents representing 3 parties under the same transaction, where I would say that their fiduciary duties may be, to say the least, questioned. Then we have a limited protection of players. We saw over the past 5 years, since 2015, an increase on the number of intermediaries that led to a decrease in quality of services. This is basically a few examples of what is the current landscape of agents. One I can remember that it's not in this slide is also the lack of protections of agents as a creditor within the football system. But exactly, this is the current landscape. Good news is FIFA is doing something about it. And this leads to my second question. What has FIFA done so far? And as you can see from the slide, there's a repetition on the word consultation, because it's basically what we've done so far since we started to implement this new agent framework. So we started with extensive consultation with the main stakeholders, as Ornella said, with ECA, with FIFPro, World Leagues Forum, federations, member association, to address what will be the best way to solve the issues that were identified previously. Following that, there were 4 formal consultation meetings with agents that came from April to September 2018. In addition to that, there was additional meetings, bilateral meetings with several agent associations. The result was easy. It was the approval in 2019, last year, on the principles of the new agent framework. Since the beginning of this year, the consultation meetings continue with all the stakeholders, member association, clubs, players, leagues, and agents on this time the FIFA preliminary proposals with respect to the implementation of the general principles. Okay, so what are the principles of this new agent framework? I would say it can be divided in 5 different principles. Let's start with the first one. The first one is the reintroduction of the mandatory license system, which includes also a further education requirement. And the objectives is clear, to raise professional standards for the occupation of agents. Basically, the idea is to have a license to be issued for an indefinite period where the agents are able to conduct their work in organized football in the worldwide basis. Second principle. So there will be, we will establish an effective dispute resolution system to solve disputes between agents, clubs, players, and coaches. But those disputes will be dealt within the FIFA resolution system that have international dimension. Third, a prohibition of multiple representation. The objective is clear, to avoid conflict of interest. Fourth, commissions being paid via the clearinghouse to guarantee financial transparency, but also to guarantee the proper receipt of the payments. As my colleague Conrado said yesterday, the idea of implementation of this principle will be at the end of the 2022 as a tentative date. And finally, the caps on commissions to avoid excessive and abuse practices. So the overall objective of the new regulatory framework is clear. Is to raise professional and ethical standards for the occupation of agents, to protect players who have short careers, and to protect contract stability and solidarity. We're aiming at eliminate, or at least reduce, the abusive practices and excessive practices which unfortunately have existed in football. So this leads to the final question. When are we supposed to implement this new agent framework? So as I mentioned in previous slides, from the beginning of this year, we started again a consultation process. And this second consultation process is related mainly to FIFA's preliminary proposals with respect to the implementation of the general principles. We had several meetings from January to April, and with member associations, with agents, and is still open to have even more consultation process with other stakeholders. At the moment, we are under the drafting and a consultation process. This means that we will have a first draft to be shared with the main stakeholders. And after we have this draft, is to consult again to see if the general principles and what was agreed are duly reflected in the new regulations. So, and we hope the main objective, of course, is to have a moderate, well thought, and responsible regulations. So, once we have the regulations agreed, the idea is to have approved October 2020 or March 2021, so that the regulations hopefully will enter into force in September 2021. So this is basically it from my side. I hope I clarified most of the questions or doubts there was in relations to this new agent framework, and I'm more than happy to answer to any questions you might have. Thank you.
Thank you very much, Luis. I'm having a look at our inbox and I can see that I got some questions. The first one that I would like to ask you comes from a student. His question goes like, what are FIFA's plans for the future regarding working with associations that represent agents worldwide? Can this foster more productive communication between FIFA and agents in order to promote transparency and professionalism? What would be your view on this?
That's a really good question that while we were drafting the first draft of the regulation, we thought about that, because the idea is indeed to include agents, the coaches, as part of this as part of a client to be represented by agents. So if we have associations be dealing with coaches, they will indeed be part of this system. And to be honest, I think they will create more transparency and more inclusive along all the stakeholders for football, in my opinion.
Thank you, Luis. I have another question from an agent in Malaysia. He would like to know what the highest amount of an agent's commission have you seen or has been declared in the transfer system?
Well, well, I remember there was an interesting one for out of contract player. There was a commission being paid around 110% of the player's salary, which I feel it's a bit excessive, taking into account the service provided for an out of contract player.
Thank you very much, Luis. I have another question from a lawyer in Uganda. He would like to know if there are any plans in like assessing the best intermediaries agents, like ranking them, and if there is any plan like that from FIFA and that this will be actually public.
Well, at the moment, we don't have a plan to rank the agents or intermediaries. I think it would be difficult to do. There definitely will be different criteria that can be put in place. Amount of commissions received, number of clients represented. I think it's a really good question that we can even consider in developing this new agent framework. What we expect in the future is indeed to release more information about commissions being paid, hopefully in individual terms. But yes, this could be a good way to increase more transparency in that respect.
Thank you, Luis. I have more questions. So, like many of our viewers are now really active and we're having this interaction that I was actually missing due to the fact that we're doing all of this online. We have a question from a lawyer in Nigeria. He would like you to elaborate a little bit more on the prohibition of the multiple representation. This means that an agent is no longer able to represent a club and a player in the same transaction.
Thank you for this question. I didn't detail much in my presentation because it was something that was already addressed before, but I will explain briefly. There will be completely prohibition of a three-party representation. So an agent cannot represent a releasing agent and player, so cannot represent three clients at the same time in the same transaction. However, there can be a possibility of having the same agent representing the engaging club and the player, but never can be the agent can never represent the releasing club and the engaging club in the same transaction. I hope this clarifies the limitation on representation that will soon to be implemented.
Thank you, Luis. Here I have another question from a lawyer. He would like to know if there are any plans to extend the scope of conflict of interest provisions on agents also to clubs, executives and administrators and professional services providers such as lawyers with regard to players' transfers.
We can, of course, we can extend those limitations and conflict of interest to all that is under FIFA umbrella, namely officials of clubs. There will be clear pre-requirements that needs to be met by someone that wants to become an agent. And one of them is for sure not being part of or acting on behalf of any club while being an official or otherwise. So, so basically, we'll have hopefully jurisdiction to enforce those pre-requirements to see if there's any violations or breaches, hopefully with the help of EMS compliance. And this is something that will be taken into account while drafting the regulations.
Thank you very much, Luis. And I have maybe time for one or two more questions. I take this one from a lawyer in England. He would like to know, and if you could give them a little bit more information about the percent of the salary cap foreseen for the intermediaries, if it's still based on 3% or which is the percentage.
Good question. This is always a topic that causes a lot of discussion, which is normal. At the moment, we have 10% commission on transfer fee from the releasing club, while the agent acting on behalf of the releasing club. If the agent acts on behalf of the engaging club, will be 3% of the salary, while if you act on behalf of the player, will be 3% also based on the salary. If for some reason there's a possibility to act on behalf of the player and the engaging club, then it will be possible to have a percentage of 6% over the player's salary. So basically there's no changes since it was approved in October last year by the FIFA Council.
And then, as I said before, we still have a few time since we had a long break ahead of us. I take the advantage that I have you here, and I mean, not me, our viewers, since I get a lot of questions for you on this hot topic of agents. I will ask you 2 or 3 more. I get one where they would like to know if this comes from a student. He would like to know if lawyers will be required to have an intermediary license once representing clients in one of the natural functions of an attorney.
Well, if the lawyer is acting as a lawyer, I think he needs to assess whether he is entitled to be acting as a lawyer under the national law. If you're acting as an agent, then he needs to, or she needs to follow the normal licensing processes. Basically, I believe back in in the past, before 2015, there was an exemption for lawyers and family members of players. But the current proposal that it's under the table is to not to have any exemption. So to have everyone that wants to become a licensed agent, they needs to follow a licensing process that will be established in the regulations.
Thank you very much, Luis. So this would actually bring clarification to the last question that I will still ask here live. It's coming from a lawyer in Italy. Actually goes into what you were saying. He would like to know if you can advise on the current position regarding intermediaries, if anyone can act currently as an intermediary under the FIFA provisions.
So under the current regulations, or yes, under the current regulations, this needs to be assessed based on each national regulations, whether it's possible or not. As the person will probably know, the intermediaries only provide a framework of minimum requirements to be established by the national association through their own intermediary regulations. So these have to be assessed in terms of the member association that enacted the relevant intermediaries regulations.
Thank you very much, Luis. Thank you for your time. We had taken advantage that you're here to answer some of the questions of our viewers. And now I would like to start the break. After the break, we will rejoin at 4 o'clock Central European time. And then we will have an hour and 15 minutes of various presentations on the status and transfer of players, obviously one of my favorite topics, and I expect many questions. So please send your questions, take advantage that we have the experts here who are more than happy to answer all your questions. So see you back in more or less 25 minutes at 4 o'clock. Thank you very much. Welcome back to the second part of the second day of the Football Law Annual Review 2019 online edition. Please take your time to send us questions during the presentations so that while our speakers are having their speech, I can actually manage the questions and we don't get them once the presenter is already leaving the room. For the next hour and 15 minutes, we will have a nice journey into player status matters. We will start with the head of player status, with Erica Montemor, and she will give us an overview of the player status department of the year 2019 and 2020. So now I'm pleased to give the floor to Erica.
Thank you very much, Maya. Hello, good afternoon, good evening, or good morning, depending on from where you are watching us today. First, I'd like to break protocol here and say thank you to FIFA, to the President, Gianni Infantino, to Alasdair and Emilio for the support they gave me through a very difficult time in my life. So I want to say thank you and say that I'm really happy to be back. As my colleague Ornella said before, it is sad that we could not be in Buenos Aires. And so I hope that everybody is in their houses safe watching us. I'm from Brazil, and as you know, South America is not in a easy position, so I'm sending all my love to all of you. So to start, as advanced yesterday by Emilio, I will share with you some great news and results, and also present you the new player status department. But before doing that, I want to invite you to come with me on the journey and look back on the dispute resolution system within FIFA. So basically, we'll go back to 2001 and say that already at that moment, the Player Status Committee, which is one of the standing committees in FIFA, was already competent not only to check the regulations, but also to take decisions on contractor disputes involving clubs. But in 2001, within the review of the transfer system, FIFA established the Dispute Resolution Chamber, a deciding body that is composed by clubs and players representatives and that passes decisions in employment-related disputes of an international dimension, free of cost. Well, I would have to say that the ones that know me, I've been in FIFA before, and I rejoined FIFA in December 2018. So I know the history, and it's to say that I really believe that both the Player Status Committee and the Dispute Resolution Chamber, which I will say now PSC and DRC, not repetitive, that they set a global example in providing a dispute resolution system within football. And again, another incentive is that the decisions passed by the DRC and the PSC were enforceable by the disciplinary committee. So here what we have is that the members of both bodies, they have a specific knowledge of football and in the particularities of the transfer system. And also I believe that both the regulation, the status and transfer of players, the RSTP, and the procedural rules governing both bodies provides all the members and all the parties legal certainty because the same rules will apply for international disputes. And as I said before, really the enforceability of the decision via the sports system is really important. So here what we have is that the first proceedings date back to 2002. And of course, at that moment, it was a very different scenario with few cases and few meetings per year. This was a novelty, a dispute resolution system within football. And at that moment in time, it was a process of trial and error, learning together with the members of the DRC and the PSC. Of course, the system has evolved since then, more than 20 years, but also the number of claims lodged before both bodies and pending the Status Department has increased exponentially. I can think of many reasons for that, but I'll try to sum up a few of them. So I would say, first of all, the easy access to large claims and the fact that it's easily seen in the procedure, how can the parties do that? The fact that for employment-related disputes involving players, this is free of costs. And again, the success of the system is itself and the possibility to enforce the decisions. But also there's one other important landmark here, which is the implementation of the transfer matching system. Because through the TMS, the parties could now lodge claims related to solidarity mechanism and training compensation within the system. And for sure, this was the one that has the biggest impact on the workload of the player status department. So through these many years, a significant backlog was created and resulted in proceedings taking a long time between receipt of the claim and passing a decision. So parties would complain of deficiency and the fact that it was taking too long to receive decisions. And the peak of this backlog was reached, and at one point we had more than 1,500 cases pending, with a backlog of over 4 months. So then, now that we went to that, I would refer to Ornella that explained about the transfer system, to say that since 2001, as I said, the transfer system remained basically unchanged with just a few amendments. And so a reform was really overdue. And finally, in 2017, under the leadership of the President Gianni Infantino, the first global reform of the transfer system finally arrived and was launched, revealing the most pressing issues, but also opening an ongoing discussion and revision of the transfer system, which is still in place, as Ornella has explained. And another important landmark is that the creation of the Football Stakeholders Committee, that involving all the football stakeholders in the discussions and in the review of the transfer system, which also had a great impact and a good impact in the dispute system and in the DRC and the PSC. So now we are again efficient and effective forum to solve disputes between all the football stakeholders. So finally, I will give you the big news that was anticipated by Emilio and the numbers. I will have to read because there are many numbers, but I'll do my best to inform you. So here's that the news is that we finally have been able to clean the backlog. So here we have with the impressive numbers. And we can now deliver an efficient system for solution of contractual disputes. It has been a very busy year since last time we met here at FIFA in the FLAR 2018. At that moment, I had just recently rejoined FIFA. And now comparing the numbers that we presented at that moment, in 2018, more than 1,000 cases were submitted and decided by our deciding bodies, the DRC and the PSC. At that moment, there were 1,138 cases decided. And in last year, 2019, we almost doubled the amount of cases submitted and decided. We reached the impressive amount of 2,023 decisions passed by the deciding bodies. And even more impressive is that we're keeping the pace. And in 2020 already, since January until today, 1,123 decisions have been passed, which means that it's already almost the same amount of cases decided if you compare to the year 2018. So these are the big news that I have, and I'm very happy and proud to be part of this team. And as Ornella said, I've been here before and back, and it's really great to be part of this transformation, not only with the reform of the transfer system, but also of FIFA and the different departments in the legal division. So now continuing, I think another landmark here is the initiative to use the proposals in solidarity mechanism and training compensation, which you will later hear more details about jurisprudence with my colleague Martins. But here it's important to note that the procedural rules already foresee the possibility of using proposals for straightforward cases related to solidarity and training. But this was rarely used. So considering when I came back and received the amount of cases and that the big backlog was also due to the amount of claims related to training reward, it was decided to use the proposals. And here it was important to see that it really works, that we have in all the cases that are straightforward, submit a proposal. And as you can see, more than 70% of the cases, the parties either accept the proposal or do not reject, which means that at the end, it becomes final and binding, which is a much more efficient and less cost to solve disputes. So here again, if I compare, doing the comparison of the last year of the FLAR and this year, the past years, is that more than 100%, is an increase of more than 150% of cases solved by the player state department, which here includes the decisions taken by the different bodies and the proposal that became final and binding. So I also like to just mention, because I'm not going to enter the details since my colleague Julian will later explain about the transfer of minors, but it's to say also that there's been an increase in efficiency and that we're also working on registration and minors to make sure that the service provided to the football stakeholders is at the same level. And again, now changing to another great achievement, I'm going to talk about the enforcement of the decisions of the DRC and the PSC. As you know, before, all the decisions passed by our deciding bodies were enforced via the disciplinary committee. And here, the same way we had a backlog, the player states department, the disciplinary department also had a backlog, which meant that the parties would have to wait a long time to receive a decision from the player states department, and then also to enforce the decision in case the party would not comply with the decision passed by our bodies. So here also the disciplinary department led by my colleague Carlos also did a review on the internal processes and has been able to really clean the backlog and has also showed amazing results even before the player states department. And now there is no backlog in the disciplinary, and so the decisions are enforced whenever needed in less than 4 months. So now that I spoke of all the numbers, I would like to talk about how did we do that and what happened in the past year. So here I would say that already at the end of 2018, since December, we started reviewing the proceedings, reviewing the internal process of the department, but mirroring what was done in the Football Stakeholder Committee, we invited the stakeholders to discuss and check what were the problems or what were the big issues that we need to solve and what were the possible solutions. So here is a great initiative from the department that is also in line with the subdivision, the Football Regulatory Division, led by James, and basically it's to achieve the goal set by Emilio for the legal division. So as I said, we started this at the end of 2018, and what we saw, as I already explained before, is that the biggest challenge was the backlog of the cases pending before the PSC and the DRC. And so the main idea here was how we're gonna tackle this and how we're gonna solve the problem, so we can then focus in other areas. And so we started reviewing, and in this we counted also on the legal counsels of the department and the administrative staff to review and find what were the problems. And what immediately came to mind at that moment was we need to be modernized, we need to digitalize our cases. As you know, the ones that have been lodging claims before the States Department for a very long time know that we used to have faxes, and then we changed to email and cargo link. But still the cases were paper files. And then so what we started doing is that the paper files became electronic files, which made us faster and more efficient. Also we would have more swift proceedings. So apart from that, we also realized that the procedural rules had remained almost unchanged and that we need to review that. And so this is what we did. But of course, knowing that we need to do a procedure that was more efficient, but still guaranteeing the respect of the right to be heard of the public. So we have simplified procedures and established more flexible time limits. And also in line with the code of the Court of Arbitration for Sport, we also made sure that the parties now understand that each party has in principle, one opportunity to submit their claim or their position with all the arguments related to admissibility or to the merits. and at the same time, provide all the documentation they intend to rely on. And the second exchange of correspondence will only be for exceptional cases with complexity. So this also gave us, allowed us to be faster and more efficient. And finally, with the entry into force of Article 24 bis, back in June 2018, the DRC and the PSC also now decide on the consequences of the non-fulfillment of the decisions taken on the same occasion. What does that mean? It means that now the parties do not need to go through different proceedings for execution monetary decisions involving clubs and players. They don't need to start a new proceeding in the disciplinary committee, but that the enforcement of the decision is done by the player status department, which is good for the parties, but at that moment in time meant that we also have this workload on the hands of the player status department and under our competence. So we had to make sure that this would not affect our efficiency as well. So we could not solve the backlog problem and create a new one. So here we review the responsibility of the parties internally, and we invite the stakeholders for a discussion, which ended up being in the circular letter 1686 of August 2019, where we explained to the parties the proceedings and how would that work. And now we have many cases being already enforced by the team. Okay, now after more than a year, I want to say here that there is no magic or miracle, but this is the result of hard work of everybody. Hard work from the legal counsels and the administrative staff of the Player States Department that have prepared and submitted more than 3,000 cases for decision. As a team, we have achieved amazing results, and the numbers speak for themselves. So I want to give a big thank you for my team and say that it was only possible because of you. But again, cases do not get decided by themselves. This was only possible because of the commitment, the flexibility and availability of all the members of our deciding bodies, the DRC and the PSC. They were available for many meetings, many times per month, to go through thousands of cases. So again, also a big thank you for all the members. So this is the new Player States Department that I wanted to present to you. That basically, after we managed to tackle the biggest issue we had, which was the backlog of cases, that now we have an efficient department that manages the cases submitted to FIFA in a fast and swift manner, providing decisions of first instance that then are appealable to the Court of Arbitration of Sport. As you've seen yesterday with my colleague Miguel, the results of all this hard work are now in the hands of the litigation department and playing at the Court of Arbitration for Sport. So after the start of the digital transformation and the review of the internal proceedings, we are now a modern department. And I also like to make reference to the transparency. As we know, already before the decisions were published, but they were anonymized. And now in legal.fifa.com, parties can have access to all the decisions where they were notified. They're published with all the details, unless the parties can ask for confidentiality justifying the request. And finally, to say that since we cleaned the backlog and modernized the department, we now have more flexibility. Flexibility to continue to review the internal process, to focus on other areas, be available to provide fast response to the stakeholders, and to continue to provide good service to all the parties. Having digitalized the cases and reviewed the proceedings will also prepare us for this moment. In spite of the unexpected lockdown we all were put through in March this year, we are ready to hold all the DRC and PSC meetings remotely and continue to hold 3 to 4 meetings per month and run business as usual. So the work was not directly impacted by COVID-19. And here again, I need to thank the members of the department for their hard work under exceptional circumstances, and the judges for their flexibility to adjust to the new reality and allow us to continue to work. Of course, cleaning the backlog of and dealing with more than 3,000 cases in this past period, not everything is perfect. And for sure, there is room for improvement. but our commitment is to provide a good service to the football stakeholders based on 3 pillars: efficiency, consistency, and quality. Specifically, we are committed to have a case management system that provides for decision in 4 months, including grounds, as already advertised by Amelia. And here we also commit to finally continue to review the process with internal consultation and inviting the stakeholders also to collaborate, making sure that we continue to improve and we continue to find ways to be more efficient and have more quality. And also what really makes me happy is to think that this means that I also have time to work in other projects, because now the backlog has been dealt with. We focus on the most important task that we have, that is solving disputes and transfer and minors, but also now we have time to work on other projects. And as Emilio said, we will continue to work on that, such as we've already seen, the commentaries to the RSTP, long overdue and expected by everybody. The report on the player status department gives you more visibility and information for all the statistics regarding contractual disputes, minors, and transfers. The football law program, as well as other projects. And under the leadership of James as well, that continue to work and provide the stakeholders and the parties with more information, updated guidelines about minors, about eligibility, provide more clarity and certainty. I don't know how I'm doing with time. Is it right here?
We still have a few minutes for a question.
Okay, so just to say that, of course, I bored you with numbers, but I had to share this because I'm really proud to be part of the team and to show these results. But you'll then, after this, hear my colleagues, Marisa, Pascal, and Julien, talking about the really interesting matters, which is the jurisprudence of our deciding bodies. And for now, I want to thank you very much for listening to us, and I'll pass back to Maya to see if there are questions.
Thank you very much, Erica. We are time, so we got a few questions. I will ask to you one, which is a very general one, considering that afterwards we have colleagues from the department that will go into more detailed points. We have a question from a lawyer in the Bahamas, and it's related to the COVID-19 document. And he would like to know if any cases have been lodged before the FIFA bodies in connection with the implementation of the new guidelines, and how many, if this is the case, and if you are able to discuss a little bit the outcome.
Thank you very much, Maya. Thank you very much for the question. We are fast, but we're not that fast in the sense that, just joke aside, is that yes, I can confirm we had received already a few claims related to COVID-19. It's currently 15. I'm looking at Pascal and he's confirming. So we have 15 cases so far, but they have not yet been decided on. So they're still under current investigation, but they will submit it soon in the next month in a meeting to exactly analyze these cases, considering the RSTP and also the guidelines and the FAQs that published lately. So this is what I can tell you for now. The outcome is not yet there, but I'm sure there are going to be grounds requested and they will be published as soon as they are notified.
Okay. Thank you very much. So then we can continue with the player status presentations, and we will move to our next speaker of today. It's Marisa Dominguez Rubio, FIFA Senior Group Leader, and she will talk to you about the contractual disputes. Marisa, the floor is yours.
Thank you, Maya. So good morning, good afternoon, good evening to everyone. It's a real pleasure for me to be here today presenting to you some leading cases of the Dispute Resolution Chamber and the Player Status Committee. And a big thanks to Emilio, Erica, and FIFA for giving me this fantastic opportunity. So the first case that I will present was decided by the Dispute Resolution Chamber and is related to egregious circumstances. Just to give you a bit of a context of this topic, in June 2018, the regulations on the status and transfer of players, so-called RSTP, were amended. Among the amendments, there were some changes in the Article 17, giving more specificity about the calculation of compensation due to a player. And in addition, it was established the additional compensation. The additional compensation could be increased due to egregious and exceptional circumstances. So as from the inclusion of this provision in the RSTP, the DRC started to apply this provision, and we have some cases. For example, the following case that is one of the cases in which this article was applied by the DRC. Is the case of the player Cristian Tanase from Romania against the Turkish club Eski Serhispor. I hope I pronounced it correctly. The main facts of the case are that the player and the club concluded the contract in July 2018, valid until 31st of May 2020. 1 month after, more or less 1 month after, the claimant sent a correspondence to the Turkish FA requesting to be registered with it and given 7 days to finalize his registration. Otherwise, he would consider that the contract was unilaterally terminated. 4 days after, the club sent a letter to the player saying that they will register him and giving a deadline saying that they would register him at the end of the first registration period that was planning to finish on the 31st of August 2018. In other words, the club indicated to the player that he will be registered by no later than 31st of August 2018. 1 month after, on 20th of September 2018, the player sent another correspondence to the club requesting a sign-on fee, which was agreed in the contract and was due on the date of the signature on the contract and remained unpaid by the club. The claimant gave to the respondent a 50-day deadline to comply with the said payment and to remedy the default. Finally, since the player didn't receive the requested payment, on 8th of October 2018, the player unilaterally terminated the contract based on the 2 overdue salaries and the sign-on fee due. And subsequently, the player launched the claim in front of FIFA. The club on its side didn't reply to the claim of the player. Therefore, the player's allegations remained uncontested. Based on the evidence at disposal, the DRC considered that the club failed to pay the player's salaries from August and September at the moment of the termination of the contract, that it was in October, plus the mentioned sign-on fee. In this respect, the DRC referred to Article 14, paragraph 1 of the RTP, according to which they took into account that outstanding remuneration due towards the player, that the player had duly put the club in default, and that the player granted 15 days to remedy the default. In other words, the DRC considered that the player had just cause to unilaterally terminate the contract with the club, and therefore, as a result, the club should be held liable for the early termination of the employment contract. So, since the DRC mentioned the Article 14 bis, here I present to you an overview of this article that has some requisites. So, this article regulates the termination of a contract with just cause for outstanding salaries, and it requires that at least 2 monthly salaries are overdue, that the club unlawfully failing to pay, a player's written default notice sent to the club, and the players granting 15 days deadline at least to the club to remedy the default. Coming back to the case, so we focus on the consequence of this particular case. The first consequence, of course, is that the club should pay the overdue, the outstanding remuneration, the 2 monthly salaries plus the sign-on fee that were agreed in employment contract, and also the club should pay a compensation to the player, which in principle will be equivalent to the remaining value of the early terminated contract. In this case, since the player had a new contract, the amounts received by the player during the validity of the previous contract will be taken into account as mitigated. And since the contract was terminated for outstanding salaries, the additional compensation of Article 17, paragraph 1, 2 of the RCP is applicable. As a general rule, an additional compensation, according to our regulations, are 3 months' salaries, but if there are egregious circumstances, exceptional circumstances, the DRC can increase this additional compensation up to a maximum of 6 months. In any case, the overall compensation cannot exceed the residual value of the prematurely terminated contract. So the DRC decided that in this case, decided to grant an additional compensation of 6 months due to the following egregious circumstances. The DRC considered that among the player's fundamental rights under an employment contract is not only to timely receive his remuneration, but also his right to access training and his right to give the possibility to compete in official matches together with his fellow teammates. Therefore, the DRC considered that by refusing to register the player, the club effectively blocked the possibility to access to competition, violating in this way one of his fundamental rights as a football player. The DRC insisted that by wrongly letting the player believe that he would be registered before 31st of August 2018, the club acted egregiously and severely prejudiced the rights of the player's rights. For this reason, they applied these egregious circumstances. That's it for the first case. Now we will move to the second case. This case was decided by the Player Status Committee in September 2019 and required a lot of media attention due to the tragic circumstances surrounding the case. Is the case lodged by the French club Nantes against the Welsh club Cardiff City in connection with the transfer of the late player Emiliano Sala. The main facts of the case are the following. On 19th of January 2019, Nantes and Cardiff City signed a transfer agreement involving a transfer fee of 17 million euros. 2 days after, on the 21st of January 2019, the player tragically passed away in a plane accident. In this contractual dispute, the conditions for the validity of the transfer agreement were established in this transfer agreement were 4 conditions. First condition was the player successfully passing the medical examination. The second condition was a mutual termination agreement should be concluded between the former club Nantes and the player. Then the third condition was that this mutual termination agreement was registered by the French league. And the fourth condition was that the French league and the Welsh Football Association of Wales would confirm to the clubs Nantes and Cardiff City that the player was registered for Cardiff and that the relevant ITC was issued. These were the 4 cumulative conditions that has to be fulfilled for the validity of this transfer agreement. So now I will present the opposing views of both clubs. On the one hand, Nantes considered that the 4th conditions were for the validity were fulfilled. The player passed his medical examination, the termination agreement signed by the parties were ratified, were registered and ratified by the French league. Cardiff announced the transfer of the player And finally, the ITC was issued by the French Football Federation in favor of the Football Association of Wales. On the other hand, Cardiff considered that the employment contract uploaded in TMS had been considered invalid by the Premier League, and therefore the ITC had been released upon an invalid contract, thereby not complying with the FIFA regulations. For these reasons, Cardiff City considered that the fourth condition for the validity of the transfer agreement was not fulfilled. Nantes highlighted that the standing established jurisprudence of the FIFA deciding body, the validity of a contract cannot be made conditional upon the fulfillment of formalities that are on the hands of the other club, and that in this particular case, the player's transfer was never conditional to the registration of the employment contract with the Premier League. Cardiff City added that the ITC had been delivered to the Welsh FA rather than English FA, and that the Premier League refusal to register the player determined the non-fulfillment of the transfer conditions. So now we will see the considerations of the PSC. First, the consideration of the PSC regarding the third condition for the validity. That it was the mutual termination agreement registered by the French League. The Player Status Committee considered that regarding this condition, it was important to analyze which was the real intention of this provision, the real intention that moved the parties to establish this provision in the transfer agreement. And the PSC concluded that this provision, it serves to provide a safeguard for Cardiff against the risk of being involved in a potential claim for a breach of contract by Nantes against the player. In other words, the PSC concluded that the third clause maintained the sole purpose of Cardiff from the consequence of a possible inducement. In addition, the PSC pointed out that Nantes produced a copy of the relevant termination agreement dated 19 January 2019. As a result, the PSC concluded that the third condition for the validity of the transfer agreement was fulfilled. And then the PSC continued analyzing the fourth condition. First of all, the PSC underlined that this condition constituted the core of the legal discussion between the clubs, and that this condition requires that the French League and the Football Association of Wales confirmed to Cardiff and Nantes that the player was registered for Cardiff and that the player ITC had been issued. The PSC established that the registration of the employment contract is an internal dual responsibility for Cardiff and the Premier League and or the Welsh FA. Therefore, Cardiff's due diligence requirements regarding the contract can in no way affect the validity of the transfer agreement concluded between Nantes and Cardiff. In addition, the PSC underlined that the contract was not approved by the Premier League because of omissions, formalities, omissions from Cardiff. And finally, the Player Status Committee underlined that on 21st January 2019, the Football Association of Wales entered the registration date in the TMS and confirmed the receipt of the ITC on the same day. In conclusion, by carrying out these two steps, the transfer was completed in TMS by the Football Association of Wales. In view of all the above, of all the aforementioned, the PSC concluded that the player's transfer from Nantes to Cardiff has to be considered as validly concluded, and therefore Cardiff City paid the first installment agreed to Nantes amounting to 6 million euros. However, this decision, the decision of the PSC, is not final and pending, and the moment is currently pending before CAS. So we have to wait for the vote. This is all my presentation. I remain available if you have any questions.
Thank you very much, Marisa. Indeed, we have many questions. What I will try to do is I will pick 3 or 4 questions so that we still have time for you colleagues to have their own presentations. I have a question, a more general one, coming from a French lawyer, and he would like to know if you have any figures in connection with from where you get most of the cases by countries, labor disputes between clubs and players.
I don't think we have geographically figures. It can be divided for matters. It's not the same, the dispute that we receive for solidarity and training, for instance, that the employment-related dispute. But regarding employment-related disputes, I don't know if you have, Erika, different information. In the report of the player status department, this information will appear. So I think you will see all the information.
Thank you very much. Then I have another question from a Turkish lawyer. He is coming from a club and he would like to know if a club has paid all salaries to a player until the last day of February and does not pay March, April, and May, if the player can unilaterally terminate the contract based on Article 14 bis, and if then this is considered as force majeure.
Well, as I explained before, the Article 14 bis is quite clear and quite specific. So if there are 2 monthly salaries outstanding, this is enough under the light of Article 14 bis, together with the default notice sent by the player and the deadline, the granting this additional time to the club to pay. If the 3 conditions are fulfilled, then the player in principle would be entitled to terminate the contract for outstanding remuneration under the light of this article. I hope this explains what you are asking.
And then I have another question from a South African lawyer in connection with the new Article 17 of the RSTP that provides for legal certainty regarding the compensation to be paid in the case of a club breaching a contract. We have now a clear objective mechanism to calculate the compensation owed. However, it does not provide for any legal certainty for the opposite scenario in the case of a player breaching a contract. And the lawyer would like to know if FIFA will regulate this gap to have also legal certainty there.
In fact, the FIFA regulations also regulates this scenario. The contract, an employment contract, can be breached by any of the parties. And of course, our dispute resolution chamber analyze all the facts and arguments presented by the parties and evidence, and will decide. And of course, we have a jurisprudence, some cases that the contract was breached by the player and compensation granted to the other party.
Thank you very much. And now I would like to pass on to our next speaker of today in solidarity mechanism and training compensation issues. I'm very happy to announce Pascal Martens, FIFA acting group leader, and he will give you an update in this very interesting topic. Pascal, the floor is yours.
Thanks a lot, Maya. Thanks a lot also to all the people watching around the world. I know you have been waiting long for this. Initially, this presentation would have been given in Buenos Aires by my colleague Alex Klotz, but finally the moment is here that I can present you the presentation. So next to him. Today, as you will have seen in the program, we speak about solidarity contribution and training compensation. 2 interesting topics, highly relevant. Especially the smaller teams are really affected by this. A short overview of where we're going to speak about today. Where we speak about, I will first give a short introduction in the regulatory basis of the solidarity training compensation concepts. Furthermore, I will shortly speak about the proposals, Thereafter, I will present you some facts and figures. That's also highly relevant to see how the workload is going at the moment. And we finalize with jurisprudence. We have two interesting topics for you to discuss about cases that give you some insight. So I'm very happy to speak about that. Well, as to the third topic, the regulatory basis and the amendments. The regulatory basis for the training compensation and for the solidarity contribution are in the regulations on the status and transfer of players. Article 20 and Annex 4 speak about the training compensation, whereas Article 21 and Annex 5 speak about the solidarity contribution. A short recap, the training compensation, that's a concept that awards training a player and is in principle limited in time. It is payable at the moment the player signs the first contract as a professional, so he's registered as a professional, that's the official criteria. And furthermore, it is also applicable on a subsequent transfer of a player between clubs of two different associations. The general rule is that transfers up to the age of 23 are applicable in the training compensation, and for training incurred until the age of 21. And furthermore, the calculation that is depending on the training costs of the new clubs category. In the afternoon, we already saw shortly some explanations about the recategorization in the new structure by Ornella. So this will soon be renewed, but for the moment, we base ourselves on the numbers that Ornella already showed you. Shortly, the solidarity contribution. Solidarity contribution that is applicable and can apply throughout the entire career of the player. When a player is registered between the age of 12 and 23 with his training clubs where he played as a young player, these clubs profit from every transfer this player makes, whether it's a temporary or permanent transfer, and the system aims at awarding compensation to a club that contributes to the training of a player. So highly relevant concepts. A lot of young smaller clubs benefit from this. Very short what it is. The amount of solidarity contribution is 5% of any compensation that's paid for the transfer of a player. It does not include training compensation, and it's payable to the player's former club. The calculation is as follows. The seasons between 12 and 15 counts for 5% of the total amount of 5%, and seasons thereafter until the age of 23 are worth 10% of the 5%. The way these proceedings are dealt with is also laid out in Annex 6 of regulations. I already introduced you some amendments we had in the past and that are highly relevant for now. The first one I would like to speak about is the Circular 1709 that was issued on 1 July 2020. Will at least come into effect as from 1 July 2020. A significant change introduced in this circular is that the solidarity contribution will, as from 1 July 2020, also apply on domestic transfers with an international dimension. To give you an example, because it always clarifies it a bit, it's exactly the example that was already mentioned yesterday by my colleague James, the transfer of Virgil van Dijk, who was registered in the Netherlands with FC Groningen, and then made a transfer for a huge amount of money from Southampton to Liverpool. Would this transfer have happened after 1 July 2020, then also solidarity would have been due. As you all know, the transfer took place before 1 July, so that specific example is not applicable here, but it illustrates good the new concept. Furthermore, the articles about training compensation have been updated to codify the existing practice and to also harmonize the language. You will see the amendments in Article 22E and Article 20. It's just a codification of the current processes we have and the current jurisprudence. So this is always of help. The next circular that is relevant and that introduced some changes is the Circular 1694 that was issued on November 2019. That circular aims at simplifying our proceedings, as already introduced by Erica. The goal is always to simplify our proceedings, to create an optimal balance between quality and quantity, and to make the processes more efficient. For the solidarity and training contribution, what is relevant is that for solidarity claims, we do not longer need an explicit amount, just a percentage of the solidarity that is claimed, that is enough. Furthermore, and that is a thing that affected a lot of clubs, We will not charge any more advance of costs regarding in claims regarding training compensation and solidarity. Furthermore, the proceedings are relatively simplified. The amendments in Article 9.2 aim at completing a claim, and otherwise we consider it withdrawn. And furthermore, this is an article that is introduced in November 2019. Due to the current COVID pandemic, it's already changed a bit, but the idea was that we send grounds of a decision only to the party which has paid the procedural costs that are imposed on it. Another important aspect, as you could see in the overview, the proposals we are making in solidarity and training compensation claims. The topic is already briefly touched. I will go a bit more in detail with you. These topics were introduced in the Circular 1689 that was introduced on 21 August 2019. Shortly summarized, the standard in solidarity and training compensation cases is that we, as from now on, always aim at submitting a proposal to the parties. In this proposal, we make a calculation of the parties. They have 15 days to contest the content of it, and if it is not contested in 15 days, this proposal is considered binding on the parties. It's proven to be an efficient way in solving the cases. It works smoothly. A lot of parties accept the proposal. We have a success ratio of close to 80% even. I will later on show you some more figures on how this is really to be placed in the workflow, but it's a highly efficient procedure. Of course, there's always the option to reject a proposal if one of the parties deems that FIFA did not make the correct proposal. If it's objected, we will grant an additional 5 days in order to submit some argumentation as to why the proposal is not correct. An extension of 10 days is in circumstances possible. And how it goes further from here is you see in this sheet. Once the proposal is rejected, we will, of course, prepare the case for a decision, as it used to be in the past. We send a proposal to a judge, which decides via the TMS system. Once we have the decision there, we aim at confirming the decision to the parties very soon, in a couple of days. And the grounds, if they are requested, they will be sent. We aim at a day of 21 days to send the grounds. So in short, parties have, under the new concept, a very, very fast decision and clarity about their claim, which is important for every club in the world, I would say. Then some facts and figures, because a picture sometimes shows more than 1,000 words. I will try to not speak too much about it, but these pictures give a clear insight in how the process is developing. Just to see a bit about claims received. See over the course of years, there's a big upward trend ongoing, the claims received. Every year we receive more claims. Last year, 2008, we received 1,158 new claims from parties all over the world. I cannot mention one country in the world where we did not receive a claim from, so there are a lot. I already gave you a sneak preview for the year 2020. You see there, these are the numbers until the beginning of June, so we are almost the same line as the year 2019. So we receive a lot of new claims, and that's important to tackle. You see, we receive significant more solidarity claims and training compensation claims. That has always been the case, and this trend is still confirming. What is now relevant, and that is a question every one of you might have, how do we tackle this amount of cases? We tackle it fast and efficient. As from 2019, you see a change in the columns here. As from 2019, we close more claims than we receive, at least for the solidarity contribution, as you see in the moment. This trend we try to continue, of course, because this is the only way in order to avoid that cases pile up. For solidarity, you see it works smoothly. 2019, we closed more than we received. And this is the same for the training compensation claims. The cases are lower in total numbers, but we see also here that we close more training compensation claims than we effectively receive. So that's a trend which we should definitely continue with. Another interesting figure I want to show you here is this diagram, which shows how we close the cases. If you close a case, there's different options for it. You see in 2019 that the majority of the claims we received is closed because the parties accepted a proposal. In 2019, you see 57% is closed because of a proposal that is accepted, and a smaller part because we passed a decision, another part because there is no entitlement to one of the two concepts. Of course, to clarify, the 57% that is out of the total cases we close. The success ratio of a proposal, once that is made, as I mentioned before, is close to 80%. So these are two different factors which we should see separately. To make a sneak preview again in 2020, I see a trend that goes that we even submit more proposals and that we even accept more cases. So the majority of the cases at this moment is closed because a proposal is accepted. Of course, for the cases in which the parties do not agree, we always have the option to pass a decision by the judge. And sometimes, unluckily enough for the parties, there is no entitlement. That's a small percentage, 12, 11%. So it's limited. As you see from these trends, we made big steps in the past. The system was already good. It's even getting better. So that's, for me, a good sign. The ultimate goal is always that we pass fast decisions and that clubs get their money soon. Well, this was a part theory and some statistics. I also have some jurisprudence that I want to share with you. This is, of course, where it's all about. We selected two cases, which I will shortly speak about. I will limit a bit the time I have because we can speak for hours about these cases, but I will try to keep it short. One of the concepts that can occur in the training compensation case is that one of the parties is of the opinion that the training period of the player was already finished and that therefore no training compensation is due. You see it in Article 1 of this article about training compensation. We have cases on this. Relevant case is passed by the decision by the Dispute Resolution Chamber on 7 June. To go shortly with you through the facts, this player was registered with the payment as a professional between 2012-2017. He was loaned to another club in the season 15-16, where he played a significant amount of matches. Then he went back to the claimant, where he is not fielded at all. And then suddenly on 7 July, he terminated the contract. He signed with the respondent club, his new club. CAS confirmed our decision that this termination was made without just cause, but then the question arose, is in this situation training compensation due? There was a claim lodged in October, and the outcome of this case you will see here. The decision of the DSC, rendered on 7 June 2018, confirmed that the claim was accepted since the player did not complete his training period before the age of 21. This is relevant to know. The aspects that the DSC took into account is that Article 2, Paragraph 2, the article that says that training compensation is not due if there's a termination without just cause by the club, is also applicable here because it's not applicable here since it was in this case the player that terminated the contract without just cause. Furthermore, this decision confirmed the existing jurisprudence that the loan does not break the chain. This is a jurisprudence that is also confirmed by CAS and that shortly said allows a club where the player was on loan to claim training compensation because they effectively contributed to the development of the player. Further, the transfer fee was free of charge and it clearly had the aim to develop the player, and the circumstances were all taken into account by the DSC. The last thing that is relevant to know is that Club B was playing in the second division and that after his return to Club B, the player did not play for the claimant's first team. All these factors led to the conclusion that the player did not terminate his training period yet, and this is confirmed by CAS in 2019. CAS said that there are a lot of criteria to take into account. The first team appearance of a club is not enough. This player needs to have other factors, for instance, the value at the club, salary, loan fees, level of games, his regular inclusion in the national team, etc. So shortly said, CAS confirmed our decision, also taking into account factors that an option to take over the player is not per se confirming that his period is finished. A last case I want to shortly touch with you are solidarity mechanism and buyout clauses. If you know our jurisprudence a bit, you see that buyout clauses are in general triggering the payment of solidarity contribution. This is confirmed by the jurisprudence of the DSC and also by CAS on previous occasions. in the commentary to the regulations and status of transfer of players. There's also a reference to this. So keep in mind, in general, buyout clauses and the payment of buyout clauses trigger solidarity contribution. An interesting case we had in this respect was passed on 5 June 2018 by the Player Status Committee. Shortly, the facts were here that the claimant paid the buyout clause of 8.5 million euros as well as a solidarity contribution to a party, but the claimant requested here the reimbursement of the solidarity contribution from the party that received the money, arguing that the solidarity contribution should go back to itself. This decision was, this case was analyzed by the Player Status Committee that initially rejected the claim. Simply said, the jurisprudence of the DSC and CAS established that the wording of the player status regulations and transfers on the status of players does not prohibit that the amount specified in the transfer agreement represents only 95% of the transfer value. And this would then, by analogy, apply also to a buyout clause. Here in this case, the payment of 1.5 million minus 5% solidarity contribution, it would not have resulted in the early termination of the player's contract, since it's clear the amount of 8.5 million euros had to be paid. This represents then 95% of the transfer compensation. Also, the good news in this case is that CAS confirmed this proposal, this way of dealing with the case by the DSC. CAS said, indeed, the respondent would not have released the player for a lower amount than 8.5 million euros. So we have to assume that the amount of 8.5 million euros was the amount that had to be paid. The appellant cannot request a solidarity contribution reimbursement when it was not raised during previous negotiations. This also turned out from the case file. And finally, the true intention of these parties, the amount mentioned in the employment contract, was to be paid to the respondent net of solidarity contribution. So again, good news. CAS confirmed our decision, and I hope this could give a good insight in our proceedings. Well, I come to the end of my presentation. I don't know whether we have still time for questions, but I'm more than happy to answer them.
Thank you very much, Pascal. Well, you are a very popular speaker and you have a very popular topic because you actually got most of the questions so far, but obviously I cannot ask all of them, but due to the time, but I will try to ask you 3 or 4 questions so that we still have time for the last topic of the state of minors. Actually, 3 different lawyers asked the same way the question, so this is a very popular one. It has to do with proposals from the administration in connection with solidarity and training compensation, and they would like to know if once the proposal gets out from administration and the debtor does not reply, and according to the circular letter, the proposal becomes binding. If this binding proposal, if this means that this decision is then subject to appeal before CAS, and if not, what kind of recourse is available against such a binding proposal?
The very fact that the proposal is binding, that would in general lead to 2 questions indeed. Can we appeal before CAS, which is really a problematic way to go. What is more relevant to mention is if there's a proposal binding and there's non-payment of the proposal, that happens every now and then. What the party can do that is entitled to receive the money is to request that disciplinary measures are taken. So that's the most useful way to go. Because in the end, what counts, party wants to have their money. So if a proposal is not paid and it is binding, the most useful way would be to submit a request for disciplinary measures within the disciplinary department.
Thank you very much, Pascal. And then maybe one last question. I also see that many parties are asking in the same area. They would like to know what small clubs can actually do when the National Federation is not lodging their claims, or when actually the information put in the system is wrong. What FIFA can do to assist those small clubs?
It's limited, but what it starts with is, of course, that they raise out the issue to FIFA. Via our member association department, we can always try to get in contact with the FA to request them to provide their affiliated clubs with the correct information. But what the most important is communication. Stay in contact with your association, send your requests, and if it doesn't work, reach out to FIFA and ask us what we can do for you. In general, we could get in contact with the member association and see where the problem lies. But it's important also keep your own administration and be aware of all your registrations. It's highly relevant. So we try to intervene where we can, but it is limited because to a certain point we also leave some responsibility to the member associations.
Thank you very much, Pascal. This is all. Although we will have more questions, I now would like to continue with the last topic of today. And I'm very happy to announce our next speaker. He's actually an internal transfer. He used to be a member of the player status department in the past. Then he went on loan to the disciplinary department and now he's back in the player status department. So I'm very happy to announce Julien Deux, FIFA senior group leader, and he's gonna give you an overview about the international transfer of minors. Julien?
Thank you, Maya. Good afternoon, good morning, good evening, everyone. I'm very pleased and honored to be part of this football law annual review. Before starting with the presentation, I would like to thank every person behind the organization of this event, but also my team for the work that was done over the last year. As you've already noticed from the different presentations that have been made, 2019 has been a busy year in terms of regulatory changes, but also in terms of cases that have been dealt with. This trend obviously also affected the work done in terms of transfers of minors, which is a topic that will be at the center of this presentation for the next 15 minutes. As you all know, the rules implemented by FIFA in relation to the protection of minors have been one of the key pillars of the regulations since their very first edition almost 2 decades ago. Over the last years, these regulations have been the source of many discussions from legal practitioners, but also from the media, from the general public. To begin with, we will have a short look and refresher about the regulations, the rules that are in place in this respect, and also the amendments that were done over the years in relation to that. We will then share some statistics about the work that has been done on the topic over the year 2019. And finally, we will conclude the presentation with the latest amendments on the regulations on this topic. So to begin with, it's always good to have a refresher about the principle. Most of you know this principle is that international transfers of minor players are not permitted. This principle applies both on international transfers, that means when a player was previously registered at another association, but also in case of first registrations, that means when the player is registering for the first time in another country. In fact, as it is clearly mentioned in Article 19.3 of our regulations, the general prohibition on the international transfers of minor players also apply to players who have never been registered before with a club, for players that are not a national of the country in which they intend to be registered for the first time, and that have not been living in the country for at least 5 years. As any people close to a legal environment knows, when there is a principle, there are exceptions. These exceptions are reflected in the regulations. They're considered to be exhaustive. To the initial exceptions that are now known by everyone, that are the first one, when a player is moving to the new country for reasons not linked to football. Second one being the moves within the EU countries for players that are between 16 and 18. The third one being the so-called cross-border exception, and the fourth one being the 5-year rule, as we call it. There have been 2 new exceptions that have been added to the regulations in March 2020. Although they have been recently added to the regulatory framework, they existed for some time because they were implemented first by the jurisprudence of the subcommittee. But let's keep them on the side and analyze them a bit deeper further in the presentation. Looking back at the history of the regulations, as you know, the regulations on the protection of minors were implemented in 2001 already. In 2005, the Player Status Committee became competent to decide on any dispute arising from the regulations on the protection of minors, but also to impose the appropriate sanctions in case of violation of this provision. In 2009, a subcommittee was created and appointed by the Players Committee, to deal with every international transfer of a minor player or with any first registration of a foreign minor player. From this moment, the approval of the subcommittee became mandatory, and at the same time, the transfer matching system was introduced, and it became the platform through which every association could submit their application to FIFA. At that time, the procedure concerned all the players aged between 12 and 18. In 2015, the age limit for which an international transfer certificate was required was lowered from 12 to 10, and by way of consequence, the age for which a minor application is needed was also lowered from 12 to 10. But this doesn't mean that below the age of 10 there is no regulations, because they also apply. It's just that the subcommittee is not competent and that the responsible body is the association wishing to register the player. In 2016 and 2020, there were some, let's say, major amendments in the sense that new exceptions were added to the regulations. In 2016, we had the addition of the 5-year rule, which was also first created by the jurisprudence of the subcommittee. And since 1st March 2020, we have 2 new exceptions with exchange students and the unaccompanied refugees. And there are more changes to come, with the protection of minors being part of the reform package. In a nutshell, the principle to keep in mind is that international moves of minor players are in principle not permitted, but if one of the exceptions potentially applies, an application has to be submitted to FIFA through its subcommittee. This was for the refresher on the legal aspects and the history on the protection of minors. Now let's have a look at what 2019 looked like for the subcommittee. First of all, and although several statistics have already been shared and presented by my colleagues Jacques and Erika in particular, here is an overview of the cases that have been decided in 2019. 2019 has been another year of record in terms of minor applications. Almost 4,900 cases were decided upon, and by way of comparison, in 2018, approximately 4,000 cases were decided upon. So we have an increase of almost 25% cases. Beyond the numbers, what is interesting to note is that the vast majority of the movement concern players that were moving to the country following their parents for reasons not linked to football, but also for the ones that have been living in the country for quite some time and for which the 5-year rule applied. So this represents almost 3/4 of the cases. Then we have also several cross-border transfers, which is the exception of Article 19(2)(c), and the famous EU exception, that is the one of Article 19(2)(b). You may wonder why we already see in these statistics the exceptions that were implemented in the regulations in 2020. It is linked to the fact that these exceptions were already dealt with by the subcommittee in the previous years, and now they have been reflected in the regulations. To be a little more technical, here is what an average lifetime of a minor application looks like. So as you can see, there are different stages. The first one is when an international transfer is involved, the former association has a right to provide its position, and they have 7 days to do so. So these 7 days are in the regulations, and we have somehow no influence on that. On a side note, I would like to emphasize that whenever a move occurs for humanitarian reasons, either because the player and his parents are moving together or because the player is moving alone, the former association is not involved in the process for obvious reasons of the protection of the safety of the player. For more details on this point, you can have a look at the FIFA circular number 1635 that is available on legal.fifa.com. So the interesting thing is, once the case arrives at FIFA, it needs to be assigned to a case handler. So that means a person will be assigned to deal with the case to look if the application is complete. So it takes on average 8.5 days for the case to be assigned to a case handler. And then once it's entering into the so-called under consideration stage, where we're analyzing all the documents, if additional or missing documents needs to be requested and have to go back to the association concerned. This stage lasts for on average 11 days, 11.5 days. So that means that from the moment it is assigned to the moment it is sent to a judge for a decision, the case is for 11 days in our hands. Ultimately, once the case is with the judge, it takes on average 2 days for the decision to be passed. And if we take all this information together, you can see that the case is in FIFA's hands for approximately 22 days. Obviously, once the decision is notified, the parties, as usual, can request the grounds and eventually appeal it to CAS. Looking a bit more into the details of this under consideration stage where the application is assessed by the FIFA administration, I would like to emphasize that obviously the substance of the application that is submitted as the first place has a big impact on how the on the length of the process. If you look at the breakdown that is shown on this slide, when the applications are complete, it takes an average 3 days to go to a judge for a decision. So we go from 11 days to 3 days. So if we break down these numbers, taking into account the overall duration of 20 days, we go down to 13 days for the case being at FIFA when the case is complete, but this is extended to 41 days when documents are missing and have to be requested and are subsequently provided, or even to an average of 54 days when the application remains incomplete until the end despite our request. So as a summary, it's always better to submit a complete application to have a swift process. On that point, I would like to emphasize that there are several helpful documents on FIFA.com, namely a minor application guide that summarizes all the documents that have to be submitted. It is a really detailed document, and we're currently working on a updated version of this document, particularly considering the updates in the regulations. And this document should be a bit more comprehensive and accessible for the general public, and it should be made public in the next few weeks. To finish with the general numbers, it is interesting to note that overall, more than 90% of the cases are accepted, at least for the ones that were submitted in 2019. 29% of the cases required additional documents, so we have a slight decrease compared to 2019. And obviously, as I said before, whenever the case is complete, it's dealt with in a way faster manner. Looking at these new exceptions, the first one being this humanitarian reasons without parents. As I mentioned before, this exception was first implemented by the subcommittee and as a result of the geopolitical situation worldwide, and several criteria have to be assessed. The first one is that the player moved without his parents, that the move occurred for humanitarian reasons, and that these humanitarian reasons established that the player was escaping his country of origin because his life of freedom was threatened on account of race, religion, nationality, or belonging to a particular social group. And the last one is that the player is at least temporarily permitted to reside in the new country. A distinction is made between the different status, and up until now, the subcommittee has always considered that whenever a player is considered a refugee in the sense of the Geneva Convention of 1951, the exception is met, and he can be registered for a purely amateur club, but also with a club that has a link to a professional club or a professional club. In what concerns asylum seekers, as the process is still ongoing and it cannot be assessed that the players are indeed in need of protection at that stage, the committee considered that this exception has to be handled carefully, and that at this stage it also needs to be established that the move was for non-football related reason, which is why it was limited to purely amateur clubs. And until now, the economic migrants are left out of the scope of this exception. In terms of numbers, 32 cases were decided upon in 2019 on the basis of this exception, and most of the moves were to England, Italy, and the US and the USA. The second exception that was included in the regulation concerns the exchange students. Once again, it was implemented first by the subcommittee in view of the growing number of players that were moving abroad to pursue academic education for a temporary basis. Once again, clear criteria have been established. They are in the numbers of 4. They're cumulative. The first one is obviously that the player is a student that is moving abroad without his parents. And then the 3 other ones that are the most important ones is that the first one, that the move indeed occurred for academic reasons. That means that school education was the primary reason, that the registration is for a purely amateur club, and that the registration for the club is for a duration of maximum 1 year until the moment the player turns 18 or he comes back home. As said, these criteria are cumulative, so that means that whenever one of them is not met, application is rejected. We've had several cases where either the purpose was to have both sporting and schooling education, but also cases where the clubs had professional links with the professional clubs or where the duration was above 1 year. In all these cases, the applications have been rejected. And on a consistent basis. In terms of numbers, as we can expect, most of the applications were going to English-speaking countries, mainly England, Australia, and USA. We also have several cases with Spain. Most of these cases were accepted, so actually 68% of the cases were accepted. Last but not least, we have this limited exemption, as we call it, that was implemented in the regulation. So if you remember what I said at the beginning of the presentation, international moves of minor players are only possible upon approval of the subcommittee appointed by FIFA. Actually, this is partially wrong in the sense that some associations can request and be granted with this limited exemption. As mentioned in the regulations, the limited exemption, when granted, relieves the member association from the obligation to make a formal application for approval to FIFA. This limited exemption cannot be considered as a free pass for the associations to do whatever they want. It needs to be emphasized that the scope of the limited exemption is limited to purely amateur players wishing to register for purely amateur clubs. In any case, the association concerned is required to report on a regular basis all the players that they registered on the basis of this limited exemption. To summarize and in a nutshell, this limited exemption is a decision passed by the subcommittee by means of which an association is granted the right to somehow act on behalf of FIFA while assessing the situation of a minor player. On that point, I would like to emphasize that in any event, if an association has a limited exemption, it can always request the approval of the subcommittee for a specific case in case it has doubts on the substance of the case. And to finish with just some general numbers, since 2019, approximately 25 associations have been granted with a limited exemption, and this covers more than 300,000 registration of minor players. And to finish with, the purpose of this limited minor exemption is obviously to increase the cooperation between FIFA and the member associations, while enabling them to process in a fast manner with their own minor applications and empowering them in this sense. So this is it for my presentation.
Thank you very much, Julia. You are also a very popular person, but I have even more popular people coming after you. So that's why we will end here the part of today's presentation about the stats and transfer of players. It's actually a very large program with all the different topics. I hope that our viewers have been able to enjoy the 4 presentations. And now I will invite you for a short break. And this means that we will actually come back at 5:30, 5:35, more or less, for our round table so that you can enjoy the last part of this year's FLAR with the round table about COVID-19. So see you in a bit and thank you very much.
Okay, ja. Wo ist meine Kamera? Hi everybody, can you hear me?
Hello. Yes, can you hear me?
Yes.
Okay.
Hi, how are
Just
you?
a second.
Hello. Hi.
Hi. Hi. Hi. Just a second, please. Okay, can we make a short sound test? Sabina, I begin with you. Can you hear me?
Yes, I can hear you very well. And can you hear me?
Yes, okay, we can hear you and we can see you. As soon as you talk, you will present it on the big screen. Okay.
Okay, so shall we keep the mute in the meantime, right?
Yes, please be always muted. Only if you talk, be unmuted.
Right.
Okay.
Thank you.
Jules, can you understand me and can you? Yes, we hear you very well and we see you on the big screen. Okay, thank you. Luis, hi, can you hear me? Yeah. Luis, you still muted?
Yes, I'm mute.
Guys, I'm receiving the sound again. Are you in the same page or not?
In which sound you mean? You are actually right. It is the right place here. Please mute everything else. Only Zoom should be running and nothing else like Skype, whatever, whatever.
I think we are all, listening to you twice. I mean, there is like a loop. So we were hearing our previous conversation.
Ah, okay. Could be that the microphones are open.
Exactly. I'm hearing.
We can hear you and see you very.
Very pleased now for the last part of this FIFA Football Law Annual Review. It's the round table about the COVID-19 with the football regulatory issues. I see most of our participants here. Yes, they are smiling. They are ready for this last few minutes. We will have Emilio as our moderator, and we have Margarita Echeverria, General Secretary of Costa Rica. She's here with us. I also would like to say hello to Samar Nassar, the General Secretary of the Jordan FA, and Sabina Facciolo, the head of the Italian Football Federation, then Luis Felipe Santoro, the legal director of the CBF, hello, and Yus Karanga, the legal counsel of the Rwanda FA. So if you are all ready, and we can start, and I give the floor to Emilio.
Thank you very much, Maya. Great pleasure to close the Football Law Annual Review 2019 with an excellent group of professionals, three amazing ladies coming from Costa Rica. Hola, Margarita, Sabina, buonasera, Tom, Samar, Secretary General of Jordan FA. So thanks for having accepted the invitation to be with us. And of course, Jules from Rwanda and Felipe in Rio. Bon dia, then the Zurich. Over the last few months, since March 2020, we have seen a lot of seminars, webinars, Zoom meetings concerning COVID-19. Our friends from the IAF, our friends from Law in Sport, so some activities online in French, English, Spanish. And when we draft, Maya and I, the Football Annual Review 2019, we considered the possibility to introduce a topic about COVID-19. even though, of course, the FLAR is focused on FIFA's activity from January 2019 until December 2019. But of course, we cannot exclude the situation, what we are facing. Again, we have been very active with the first document issued by FIFA in April, then the Q&A document in June. So, you know, we cannot exclude and we cannot escape from this situation. That's why we plan a roundtable with representatives from MAs to tackle, to analyze, and to understand the consequences of COVID-19 in football. So, bearing in mind this context, the topic of the roundtable is COVID-19 football regulatory issues. And the idea is to go through the different MAs, trying to understand these consequences, and trying to share ideas, problems, and situations in the respective continents. So if I may, let's start, sorry about that, with the most experienced colleague in this roundtable, Margarita. Of course, it's not the age because Margarita is still very young, but she's really very, very much experienced. I've seen, and I see right now, the legendary FIFA casebook behind her. So that's why I can say that she's very experienced. Again, she's still very young, but she's involved in football since years ago. Indeed, she's part of the first FIFA cast panel back in 2003. So imagine the experience of Margarita. So I would like to start with Margarita. You know the topic, you know the document that we have issued over the last 3 months. So what's your experience in Costa Rica and what can you share with us from your perspective and particularly from your region?
Okay. Hi, Emilio, and thank you very much for your presentation and for this invitation. It's a pleasure to share with this audience and with excellent colleagues from other federations in this roundtable. Without doubt, COVID-19 has changed everything in life and, of course, in football as well. Let me tell you a little bit what is happening here in Costa Rica to put in context. Since the first moment that the government knew that we have COVID in Costa Rica, the first measure that we had was to lock down. You know, everybody, schools, high schools, universities, government entities, and private companies, everybody. Of course, everybody was studying at home and working at home. We have vehicular restriction and closed borders, and of course, every sport activity was canceled. So our tournaments were canceled. I can say that all of this helped to control the sanitary emergency that we have, because at this moment we have 2,277 cases and 12 deaths. That's not too bad. We are very concerned about that, but we think that we can control this. Since the tournaments were canceled, the federation took the lead between clubs and the association of players to have, with whom we have a good relationship, by the way, in order to get agreements regarding the contracts. At the end, the players, they understood the situation, because I can say that the first income that has the clubs are the incomes from ticketing. So if we don't have games and we don't have fans, we don't have ticketing and the money for that. So it was very important for the players to accept to reduce the salaries. Even, you know, for the federation was and is hard, because we expected to make 2 friendly matches in March and in May, and we couldn't do that. And we expect as well ticketing from that. But well, not everybody was too bad. And, you know, in the middle of May, we were the first league that can restart again with the tournament. And the Ministry of Health authorized to restart our tournament. In fact, today we have the final of the second league, and tomorrow we will start the finals of the first league. And the weekend, the women tournament will start again. The agreements between clubs and players are still in force until the end of this championship. We expect to restart again with the tournament in August, middle of August. And I know, and we know that the clubs right now, they are in negotiations with the players. Some of them are going to continue because the way that we have the tournaments are going to continue. The contracts, others are going to change maybe, but we can expect that they can reach a very good agreement. In a brief, this is the statement. In a brief statement, that our situation, of course, we are concerned about what is happening, but working to make things go properly. The federation has maintained a close relationship with the government, so we have their support, and that is very, very important. Just can I tell you what is happening here in Costa Rica?
Okay, gracias, Margarita. So good comments, good ideas, and good experience from Costa Rica. For sure, we will have the opportunity to come back later on. So let's move now to Europe with Sabina. Buonasera, Sabina. So
Buonasera.
Italy is a pure football country. So, you know, an amazing country when it comes to football, and football is not only so popular, it's very important. From the north to the south, I've been following the situation very close over the last 2 or 3 months, but for sure you have more insights and comments to share with us. So feel free and go ahead.
Well, thank you, Emilio. Well, first of all, I just want to tell to the FIFA team that I keep on having the return of the voices, so it's just like having, you know, 2 people talking at the same time. So I don't know if they can try to solve the technical problem. Yeah, you said that we are a football country. Yes, it is. You know, someone said that you know, we right after the first kickoff last week, we you know, there were like 65 million virologists in Italy, and now we are back 65 million football coaches, you know, again. So that was really being back to normality, and that was really nice. And actually, we already had like a little taste, you know, little bite of football, even right at the end of the lockdown, when Italy, you know, was awarded the title of EU 2020 because we won the finals against Serbia for youth football. So that was like, you know, hopefully a nice sign for the European Championship next year. So yes, we actually have finally the resumption, is you were saying, of our championships. Just the professional ones. So we have 3 leagues. So all of them had the resumption of the championship, Serie A and Serie B, although Serie C are going to play playoff and playouts only starting on the 1st of July. And we really worked a lot to ensure, you know, the condition to start, focus, health and safety, of course. But I'm particularly happy about the fact that we were able to increase the awareness all through Italy of the importance of football, not just like, you know, a game. I mean, we wanted to go back to start playing again, not just because it's fun, but because of the you know, important economic dimension of football, as that was mentioned in some previous presentation earlier this afternoon by Ornella, if I'm not mistaken. And you know, we were able to increase the awareness also of the important fallouts on the social aspects, and on the health aspects of football. And I think an outcome of this work was also the fact that the government was very supportive with us, and addressed even a special provision in a law decree addressing basically one of those that was for sure my main concern, but a concern of the whole federation, of course. That was the litigation overload. In case we would have not been able to either have resumption of the championships, or we could restart and then we had to stop over again. We were really worried about litigations. We Italians love to litigate, so I really didn't know what to expect about it. But there is this provision now granting the Football Association to decide basically everything in relation to the current and the next sports season by derogating to the rules or regulation in place. So basically, okay, there is an emergency situation. We need emergency and extraordinary rules to be applied. And of course, we cannot decide, how to either stop or have relegation or promotion as we wake up in the morning. But we have to respect, of course, the principles of law, the basic principles of sports, the indication of FIFA and UEFA. We are going to privilege the results achieved on the pitch, of course. But this is really, quite a big relief for us, because we know that the outcome is going to be fair anyway. And in case there are litigation, which are going to be for sure of a smaller number than that would have been differently, that is going to to be those are going to be decided by means of fast track procedures. Erika was very proud of shortening the length of the proceedings. Well, we already had some litigation in place that were deposited 1 week ago, and they had been already decided. So of course, first instance, they can still be appealed. But still is going to be very fast, and that is going to be a good help to be sure that we can also focus on the next season in case.
Thanks, Sabina. Thank you very much for this insight from the FIGC from Italy. Let's move now to a different place, a different continent in Jordan. Samar Nassar, the General Secretary of the Jordan FA. I can imagine that the situation is not like in Italy for too many factors, but you have very good experience. We have discussed some particular topics over the last 3 or 4 weeks. So what would you like to share with us and with those who are following the FLAR today, from your perspective and from your MA?
Hello, Emilio, and everybody watching the law review today. I have to say, maybe I'm not the legal expert in this roundtable, but I have to say COVID-19 has made us all experts and aware of the laws and the regulations to be able to support our the football industry and our local clubs and MAs. COVID-19 has for sure disrupted the whole football ecosystem. However, local realities and regional realities are different and vary from one country to another. And the response of MAs are different to this pandemic. Jordan, like Costa Rica, has also imposed very strict lockdowns in response to COVID-19. 1 week into our league, all sports activities were stopped in the country. They only resumed last week, and the league will not start till August of this year, maybe 7 months after the cessation of football. Of course, with football stopping, sponsorship revenues have stopped completely. Deals that were about to be brokered right before COVID-19 were suspended. And unfortunately, we've had to really kickstart these talks and relationships once again. Ticketing revenue, of course, without the fans and with government not allowing fans in stadiums, will affect the revenues of club. clubs. And our backbone, the government funding, has also been redirected to high priority sectors like the health sectors. And our financial funding for clubs and the Jordan Football Association has dropped by 50%. Therefore, clubs and the MA has been crippled and financially insolvent due to this pandemic. FIFA regulations that were issued earlier this year to help regulate the contractual relationship between clubs and players was helpful. However, in Jordan and in many countries in our region, without player unions and the lack of mutual agreements between clubs and players, of course, due to this escalating financial situation, there was a standstill. And without the unclarity a few months ago of when sports will resume, the Jordan Football Association had to issue its own regulations, of course, in line with FIFA guidelines and in line with local applicable laws to help clubs reach these agreements or regulate their contracts and to be able to deal with them. And the Player Status Committee in Jordan clearly specified how to deal with contracts in the time where football has stopped and when football resumes. Jordan has issued earlier this year emergency defense laws that regulate labor contracts for organizations, for companies across the country. And therefore, for the period where sports has stopped, player contracts were reduced up to 50% according to local applicable laws, knowing clubs were not able to reach these mutual understandings, unfortunately. I think moving forward, there are many lessons to be learned. The COVID-19 was an eye-opener that contracts should include force majeure clauses. Unfortunately, the majority of contracts did not have them for local players here. And many lessons learned, and I believe COVID-19 can be an opportunity moving forward to return the football ecosystem back to the regular size and to be able to meet the financial position of clubs in Jordan.
Okay, thanks, Amar. Thanks for your comments and views on this particular matter. Let's move now to Africa. Jules, the legal counsel of the Rwandan FA. So big continent, amazing country, Rwanda. I've been there almost 2 years ago for the first time, and it was amazing. So for sure you have a lot of experience and comments not only concerning your country or MA, also the whole continent, and to what extent COVID-19 and all these football regulatory issues have impacted Rwanda and the whole continent. Jules.
Regulatory point of view.
didn't have, or we don't have legal provisions in our competition rules or other regulations to tackle this particular scenario, these particular situations, because
à nos membres et nos clubs.
all these kind of issues so that we can have negotiations and collective bargaining agreements between all football stakeholders. But we also have a very difficult challenge in the country because we are short of football stakeholders. When I'm talking about the football ecosystem, we have the football associations, we have clubs, we have players associations, we have league. But in our country, we only have in the football relationship, we have the football associations and the clubs. We are short of players associations, which understandably, which you can understand that it has been very difficult to hold these kind of discussions, collective bargaining between clubs and players, because players don't have that platform, they don't have that association, that union, which can facilitate the collective negotiation between them and the clubs. So this has been a very huge challenge for us as a football governing body to facilitate this negotiation. So in a nutshell, that is our experience, which is more or less similar to other countries on the continent, to other neighboring countries when it comes to tackling and addressing the contractual related issues that have been caused by the COVID-19. So I think we also have time to discuss about that, as the government have directed us, they have issued other directives that sports competitions and sports activities can only resume in September. So now we are holding different discussions, different meetings with all football stakeholders to see how we can set up a timeline and a time frame to a return to play in a safe and healthy environment. Thank you, Emilio.
I think that you have described very well the interaction, sometimes positive, sometimes negative, between the employment law and the rules and regulations of the different federations or leagues. So, you know, we are facing the same problematic all around the world. Sometimes it's not easy to merge both legal instruments, and this situation creates some problems that, you know, we were trying to solve throughout the FIFA guidelines in April and then the Q&A in June, but definitely we are far from solve everything all around the world. Let's move now to the last MA, but the most successful one when it comes to national teams at the FIFA level. So the great Brazil. So bom dia, Luis Felipe. The floor is yours to explain to us a little bit the situation in the CBF and in Brazil. There is not only a country, it's a big continent, and we all love. So, you know, the floor is yours.
Bom dia, Emilio. Thank you very much. It's a personal honor for me and an institutional honor for CBF to be invited by FIFA for this event. I would like to thank you for that, and I would also like to congratulate my colleagues from this roundtable, Margarita, Sabina, Samar, and Jules, as well as my friends from CONMEBOL, from South American member associations, and the lawyers from Brazilian local federations and Brazilian football clubs. I'd like to begin my participation presenting an overview about the structure of the Brazilian season. This is necessary and important in order to understand the reason of the impact caused in football regulatory issues by COVID-19 in Brazil. Our pre-season starts in early January, and the local championships begin at the end of January. The clubs which play in the 4 divisions of the national championships also play these state championships in the beginning of the season. We have 26 states in Brazil, plus the federal district. So we have 27 local championships, each one organized by the local federation of the respective state. That's the reason CBF is named a confederation under Brazilian law. We are a confederation formed by the 27 local federations, each one from each state of the country, plus the one from the federal district. All of it private associations. When the local tournaments finish, the 4 divisions of the National Professional Football Championship start. Our first division, the so-called Brasileirão, used to start in May and to finish in early December. In this sense, regarding professional football, COVID-19 suspended the local championships and the Brazilian Cup. The other national competitions, including Serie A, our first division, were postponed. Although we are still facing a very hard time related to the pandemic, some local authorities have already allowed the local federations to resume their championships, to continue it. Otherwise, in other states of the country, clubs were not allowed even to restart training. So we have clubs competing in the local championship and clubs which were not allowed even to restart training. Brasileirão, our Serie A, is played by 20 clubs from 9 different states in 11 different cities of the country. When all these local public authorities allow, we will start the competition and complete it with the 38 rounds original planned. Considering all the 20 national competitions organized by CBF each year, we still have 2,455 matches to deliver on this season. In this meantime, in regulatory terms, we are dealing with the transfer window period. That's because when the transfer market opens in Europe, Brazilian and South American football clubs used to lose players for European clubs. So our transfer window must be opened for replacements. We also have some problems due to overlapping seasons in this subject. Our 12 weeks transfer window is placed in the beginning of the year, and our 4 weeks registration period is placed together with the big European transfer window. So our first window was interrupted by COVID-19. And due to the second documents issued by FIFA during the pandemic, the FAQs published this month, we will be able to exceptionally recover this lost period directly impacted by the disease. Thank you, FIFA, for that. We'll have a video conference tomorrow with the clubs from our Serie A in order to address this topic and democratically choose the new dates for our registration period. In terms of players' contracts, we have currently 7,850 professional football players under contract in Brazil. But as we have a specific federal piece of legislation regarding to football players, we could not adopt FIFA's first recommendations and guidelines related to labor contracts and lower agreements. Still on the labor side, in the beginning of the pandemic, Brazilian football clubs put players and staff into collective vacation in order to have sufficient and enough time to conclude all the matches of the season. After that, the clubs negotiated directly with its players a reduction on wages from 25% up to 70%. In some cases, this negotiation was amicable. In other cases, it was a little bit hostile, of course. In terms of government measures, last week, our federal government published a so-called provisional measure, which has the same force than a law, authorizing labor contracts with players to be signed for the minimum term of 30 days in order to enable clubs to sign players just to finish those local championships. The minimum term for a player's labor contracts under Brazilian law is 90 days, 3 months. And also last week, the Congress approved a bill authorizing sports federations to change their regulations in order to amend the players' inscription dates for the competition. It probably sounds strange for almost all of you, but Brazilian federal legislation prevents sports federations for amending their competitions regulations after published. So we needed this government measure to allow the sports federation to amend their regulations to deal with the situation of the COVID-19. Now this bill has been sent to the approval of the Federal Senate. Well, what more? During this difficult period of the pandemic, CBF has taken a series of measures to support clubs, referees, local federations in order to preserve jobs and clubs' maintenance, as well as to enable competitions to be played or to continue. Considering donations, credit lines, advanced payments, and exemptions, CBF's direct support with its own funds to the Brazilian football community has already reached more than 100 million Brazilian reais. And alongside these emergency measures, CBF continues to work to maintain and to deliver the competition's plans for 2020, keeping its commitment for investments in men's football, women's football, and grassroots. In 2019, for example, CBF invested around 535 million reais in Brazilian football on its various areas. And we want at least to keep this figure or even to increase it this year, if possible. To conclude, we also organized a campaign for raising funds with the Brazilian national team players, in which we donated the same amount that they raised themselves. The amount that collected is helping 32,000 poor families for 2 months with basic food baskets and cleaning kits. I think this is a brief but a fair overview of what we are going through in Brazil in terms of COVID-19 regulatory issues and some other situation. Thanks FIFA once again for the invitation. Congratulations for the high quality and standard of this activity. And I would be more than happy in answering possible questions from Emilio, from my colleagues of this round table, and from the viewers. Thank you very much.
Obrigado, Luis Felipe. Thank you very much. You know, it has been indeed very brief, bearing in mind the size of the country, the number of matches that you need to play, the number of professional players, regional associations. But of course, you know, we don't have 4 hours. Now in this second wave, second turn of this roundtable, you know, don't be obsessed with others, so it's completely free. I would like to ask you, what can we expect after this COVID-19 situation? So, you know, what do you see in your respective countries, but definitely what can we expect from the current situation in the next 6, 12 months, or even 1 or 2 years? But again, we don't need to follow another, maybe ladies first, or Luis Felipe or Jules again. So Margarita, ahí vamos.
Okay. You know, as Samar said, we have many lessons to learn after COVID-19. Really, for example, use the technology. I think that we never has to use Zoom or Teams or everything in order to have meetings, and all the meetings we need to be everybody in presence. But you know, even in TAS, we have done virtual meetings, auditions, hearings. So and it works very good. Solidarity, you know, solidarity and respect, to understand each party. In our case, in our legal football world, I think that the role of the federation is going to be very important and a good intermediary between clubs and players. I can understand that the players, they need to play and they need to their salaries, of course, but they need to know as well that the situation of the clubs is difficult, but the clubs don't have to abuse about that. They have to be very aware about what is happening. And I think that solidarity and respect don't we don't have we don't have to forget that thing. And I think it's a important lesson to learn about what happened here, what happened not only in football, in the whole world, and all the activities in the society.
Gracias, Marita. Any other comments from the panel?
Emilio, thank you for the question. I think, as Margarita and the other previous speaker mentioned, I think there is so many lessons to be learned from this pandemic, and to understand the consequences of COVID-19 on football. We also need to understand how did it reach us, on which level, because in our particular context, the COVID-19 or this pandemic has coincided with other financial problems being faced by our clubs. So we need to rethink the way to rethink football, the way we manage, because let me give you an example. We have certain situations where clubs, even before COVID-19 appeared, we had clubs which had already gone 4 or 5 months not paying their players. So in that situation, you can understand that the financial difficulties which was even present even before the pandemic, it needs to show us how we need to restructure and to rethink the way our football structures are structured, because you have a club which has used this pandemic to disadvantage players, whereas even the financial problems even existed even before the occurrence of this pandemic. So to be brief, I think we need to set up some specific reserve funds within our federations, within the football family, in the context, which can help us address such kind of situations in the future, because this is something which will help us to preserve jobs, to preserve contractual stability, and also to maintain our athletes in good health and in good mental state to compete at the level we need them to compete. But we also have to rethink the way we fund the lower clubs or the academies or the football centers which produce future stars, future footballers. This is also a key thing to think about when, as far as the reasons of the COVID-19 are concerned. Last but not least, I also think that it has virtually changed each and everything in football, because if you see the way football member associations of FIFA in different countries, we are dealing with dispute resolution mechanism. We are doing it virtually in some situations. This is not something which we could have even thought about before the COVID-19. We are restructuring our financial, internal financial manuals to flexibilize our decision-making process. So there is a lot to be learned. There is a lot that COVID-19 taught us. But in a nutshell, I think those are the things, those are the key areas we need to consider when we think about taking away some of the lessons from this very bad negative situation that have occurred to the whole football family.
Thanks, Jules. Any other comments, Sabina or Samar? Would you like to add something else?
I think that, you know, we haven't finished, I believe that we haven't finished, unfortunately, to see, you know, the real consequences of this pandemic event. So, of course, it will be necessary to still wait a little bit before we can really understand, you know, what's going on and how we should react. But for sure, as Margarita was mentioning, I believe that solidarity is going to be the key, you know, for every action that we are going to take and every step. And when I talk about solidarity, of course, I mean solidarity at all levels and in any you know, field. So not only from, you know, a simply economical standpoint. I mean, that is going to be basic, but that is for sure not enough.
Samar.
Yes, I too stress the importance of solidarity moving forward, because we have a new world order. This pandemic is not just going to go away. It might be with us for the next several years. And we have to be quick to adapt. Football has to evolve. We've seen many cases from leagues around the world that have been quick to adapt with this pandemic and to be innovative. And this is what we have to focus on moving forward, how to increase sponsorship revenue and despite of what is happening, how to be creative in light of no fans in the stadiums moving forward. And I think it was also a fast forward for us as an MA to work on regulatory matters. We've seen how the market for players has grown exponentially over the last few years, and clubs have been facing financial limitations prior to the COVID-19 and making it even worse now with the pandemic. So as regulators moving forward, next seasons are going to look differently. We're going to fast track the financial fair play criteria, making sure that clubs do not spend more than their revenues moving forward. And it is an opportunity, but we have to be creative and to ride that wave to come out with the least damage after this pandemic.
Thank you, Samar. Felipe, would you like to close the roundtable?
Yes, I agree with my colleagues, but I'd like to add that I think we will still have hard times in financial terms, but the football industry is solid, the football family is strong, and we will recover, we will rise even stronger.
Okay, thanks. So I think that we are running like a Swiss watch today. So it's 6:24 here in Zurich, and we expect to finish at 6:30. So it's amazing. Even the Spanish are becoming a little bit Swiss with this. So I would like to close the roundtable, thanking all our friends in Costa Rica. Margarita, muchísimas gracias. Y espero verte pronto.
I hope to see you again soon.
Again, thank you very much for having accepted the invitation. Sabina, Samar, thanks again. It has been a big pleasure to interact with you over the last days and also today on the roundtable. And of course, Luis Felipe, so all the best for your country and your colleagues. Hope you are all safe. And on behalf of FIFA, I would like to congratulate you on this today table. Thank you very much for your time and for being available for us and also for the viewers. Thank you very much.
Thank you. Thank you all.
Thank you and congratulations.
Thank you very much.
Bye. Thank you.
Now it's time to close the second day and the football law annual review is 6:30. We are very close to 6:30, and we would like to close the FIFA football law annual review 2019 that it was supposed to take place in Buenos Aires. I hope, Maya, that next year we are moving to South America, to CONMEBOL, to Argentina, Buenos Aires, and we can do exactly the same, the online version, but also with physical presence. In closing, I would like to start thanking the interpreters, not the translators, the interpreters. So I think that the quality has been amazing. I receive a lot of emails and WhatsApps from friends all around the world. So thank you very much for your help, and thanks for all your efforts in Spanish and French. Also, in closing, I would like to thank my colleagues in the IT team and digital team. It has been a big challenge for us. Of course, we are FIFA, but we are doing this with our colleagues here. It's the first time that we do something like this in a very particular period. So thank you very much to those who are involved. So from the IT, auditorium, digital, for all your help, and particularly for all your parents with me. From time to time, I'm a little bit pushy, so sorry for my mistakes, but I think that the FLAR has been a big success from IT perspective. Thank you very much. And finally, I would like to thank you very much the FIFA administration, not only those who spoke here yesterday and today. I think that we deliver very interesting presentations. It's nice to be the captain of a team when the team is fantastic. So it's very easy to put the face and moderate a roundtable. But behind me, there is a big group working every day on all legal and compliance. I'm very proud of all of them, not only those who spoke on Monday and today, also those who are delivering nice projects for FIFA. And a special thanks to Maya for having organized and lead this FIFA Football Law Annual Review for 3 times. So the first time was in Buenos Aires. She has been involved in the delivery of this project. So all the negotiations, easy negotiations with our friends in AFA. Then when we canceled this, we were very close to go on live here in Zurich. So she also coordinated this activity, and now for the 3rd time. So we are here. So thanks for all your efforts. Thanks for your help. I think, again, it has been a big success, and thanks to all my colleagues. So once again, Maria, would you like to say something in closing?
Well, there is not much to add apart from thank you very much to all the viewers for the patience. Thank you to all the ones that helped us in the background here. It was a very particular FLAR this year without an audience. I hope it was not too weird when you were watching us. Sometimes we're not sure exactly where, in which camera. And the only thing I can say, I'm very happy that from the numbers, I can see that in average, we have had around 3,000 viewers following us. This is more people than we could have fit in any auditorium. So one positive aspect of having this online. But for sure, I would prefer the one-to-one interaction, live questions, the people sitting here. So really hope to see you next year. And for sure, I really hope to see you next year in South America, ideally then also in Buenos Aires as we have planned. That's all I can say. Thank you to all of you. Thank you, Emilio. Thank you all the people that participated, and have a great evening, afternoon, wherever you are, and hope to see you soon. You will get all the presentations and all the videos. Thank you.
Thank you very much. See you next year. Muchas gracias. Merci beaucoup. Dank. And as Maya said, the presentations will be uploaded on legal.fifa.com, also with the videos. Stay safe. That's the most important thing. You, your families, friends. And again, hope to see you all next year. Thank you very much.